I'm requesting a breakout for position 4.
4, okay. All right. Is that MH?
Yes, Your Honor.
Okay. Anyone else? Because sometimes our Zoom master, we kind of have her going back and forth a little bit, which we want to be as efficient as we can. And whose case is number 4? That's you, Ms. Gant?
Yes, Your Honor.
And then for the state, whose case is that? Position 4.
It's my case, Your Honor.
Okay.
Whenever you get started, Judge, we're gonna start in courtroom 2 first.
Oh, we're gonna do 2 first, okay. So we only have that one case, Ms. Lewis. After I call, give my opening, do you want to go to that first to get it over with, since it's only one?
That's y'all call. I mean, we just want to make court move smoothly, so if the
Right, yeah,
if the defendant's ready at this point, y'all can go for it.
Deputy in courtroom 2, right, do you have position 4, Mr., is it Alex, is it Bross?
Yeah, but first, I would like to start with Miss Position 7 first, so we can get her out of here.
Okay, 7, okay,
Thank you.
appreciate it. All right, everyone, good afternoon. This is the State Court Expedited Accusations calendar for March the 18th, 2022. My name is Judge Regina Mincy, and this is the calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this is usually the defendant's initial appearance before a state court judge. So we're going to address several matters if they are right for today, including bond, possible arraignment, or consideration of a possible plea offer if one is made by the state. I will also be providing you with a state all-purpose reset date, and that is for March 31st, 2022. March 31st is the SAP day. Also, I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to also remind the defendants on this calendar that you do have a constitutional right to remain silent. Anything that you say about the facts and occurrences of your case can and will be held against you. The prosecutors are here, they are listening, so please defer to your attorneys and not make any statements that may be against your interest. All right, we are starting with position 7. And that is case number 22CR001559G. And it looks like it's O'Shea Delani. You're charged with 1 count of obstruction of a law enforcement officer, the 2nd count of disrupting public school, and then a penalty. I think that's maybe, disrupting of public schools, the 2nd charge. And both of those offenses occurred on March the 17th, 2022. Pre-trial, do you have anything?
First arrest. How many times?
All right, Ms. Sari.
Yes, Your Honor. In this case, officers responded to Benjamin E. Mays High School. It's located at 3450 Benjamin E. Mays Drive, Southwest in Atlanta. Officers were responding to a fight at the school. They came on campus and the defendant entered into the school in an unauthorized area to help her sister fight another student. Due to the defendant's age, Your Honor, we do not believe that the defendant was a student at the school, and then officers attempted to arrest the defendant, which she resisted. Your Honor, even though this defendant does have a negative criminal history, she would present a danger to the community, being that she went up to a high school to fight another person instead of following the proper protocol regarding any issues. Your Honor, the state is recommending a $5,000 surety bond for disrupting public school and a $1,000 surety bond for obstruction, with conditions of staying away from Benjamin Mays High School, one-day anger awareness course, and no drugs, alcohol, or weapons while on bond. Nothing further.
Okay. Ms. Gant?
Thank you, Your Honor. Ms. Deloney is 22 years old. She has been in the Atlanta area for 5 years. She has community ties here, including her sister and mother. Your Honor, we are opposed to the stay away at 3450 Benjamin Mays Drive. Ms. Deloney informed me that her sister, who's 17 years old, attends school there. The mother of both the children work from time to time. So if there is an emergency, we do not believe that it's appropriate to issue a stay away to disallow Ms. Deloney from going there to pick her sister up if her mother or another family member isn't available. Ms. Deloney completed high school. She is a team member at a local movie theater. And Your Honor, she denies the allegations. She states that her sister is in fact 17. She states that her sister has been bullied at that school. However, she did not go there to fight. She states that her sister called her to pick her up. Ms. Deloney states that she went to the office. The office told her to wait for a moment. She waited in line as she was instructed. She then asked office staff to show her to the bathroom. She went there to use the restroom, and she states that while she was at the restroom, she noticed her sister come up to her and ask her to come up there to where she was so that she can get her from school. She states that she was unaware at that time that she needed a pass. She states that the next thing that she knows, she was approached and arrested. She states that she has a history of PTSD from growing up in foster care. So the warrant states, and also the client denies offering any violence whatsoever to the officers. And again, she has not been charged with any allegations of a fray. Therefore, Your Honor, this is her first arrest. She again believed that she had a right to be there to pick her sister up. She does not, again, have any prior history. So therefore, I am requesting a signature bond. And again, we are unopposed to the stay away. Thank you.
I'm sorry, Ms. Gant, were you
Yes.
unopposed or were you opposed to the stay away?
Thank you for the clarification. I am opposed to the stay away, as
Okay.
we believe that she has a legitimate need to be there to pick her sister up in the future.
And Your Honor, we would just ask the court to impose that stay away, being that she has this charge of disrupting public schools. She's not a student there. So we would ask the court to impose the stay away.
Okay. And I understand her sister is 17, so it sounds like she must be a junior or senior in high school. And there is a mother as well, so they alternate in picking her up. Is that what you're saying, Ms. Gant?
Her mother picks her up if she's able to get off from work. It's much easier for my client to pick her up from school than her mother.
Well, I do understand that they're allegations, but I do have a concern. It's not too many years apart, 17 and 22. I just don't want her to go there with any disruptions. And this just happened yesterday. I'm going to order a $5,000 signature bond through pretrial. And I am going to order that she stay away from the Benjamin E. Mays High School on 3450 Benjamin E. Mays Drive. And I'm sorry, Ms. Deloney, but I need you to stay away. Let's cool things off. And there seems to be someone else that's able to pick her up, or she'll have to Uber or get a ride or ride the bus back home, because you cannot go to that school right now. You go up there, I'm sure they will call the police on you and you'll be rearrested. And then you will forfeit your bond conditions. So you're to stay away from the school. I'm going to order that you take a one-day anger awareness course. And I'm going to order no drugs, alcohol, or weapons while on bond. All right.
How's that bond split up?
Oh, I'm sorry. The $1,000 on the obstruction and the $4,000 on the disrupting a public school. So it's a total of 5. Anything else I need to take up?
Nothing further, Your Honor.
All right,
Nothing
thank you.
further. Nothing further, thank you, Your Honor.
Uh-huh.
Can we do the South Annex, position 18, Ms. Williams?
All right, this is case number 22 CR 001569A. Imani Williams, you're charged with 1 count of DUI, which is driving under the influence of alcohol.
1 second, it's the wrong person.
I'm sorry.
It's the wrong person.
Position 18.
Imani, position 18, Imani Williams?
1 second.
That's the one I have.
That's right. You keep going, Judge.
Oh, we're at the South Annex. We're not in courtroom 2. All right. Ms. Williams, you're charged with 1 count of DUI, and you're also charged with the 2nd count of following too close and a 3rd count of improper passing of an emergency towing or highway vehicle. All 3 counts occurred on March the 16th, 2022. What do you have pretrial?
The 3rd arrest. 2019 and 2020, theft by stop business conviction.
All right. Ms. Tortorella?
Yes, Your Honor. For the DUI per se charge, the state's recommending a $6,000 surety bond. For the following too close, we're recommending a $2,000 surety bond. And for the improper passing, a $1,000 surety bond. The conditions is that she not drive while she's out on bond, that she do ADET, no drugs or alcohol, no weapons, and no new violations of Georgia law while she's out on bond. Your Honor, on March 16, 2022, around 11 p.m., a deputy investigator S. Moncrief, and for the record, that's spelled M as in Mary, ONCRIEF as in Frank, of the Fulton County Sheriff's Office responded to Piedmont Road Northeast and I-85 Expressway ramp in reference to a sheriff patrol vehicle struck by a motorist. Upon arrival, the deputy observed a black Chevy Cruze with airbags, deployment, and severe front end damage caused from striking the rear of the Fulton County Sheriff's Office fully marked patrol vehicle. The patrol vehicle was stopped in the right lane with full emergency blue and red lights activated. Defendant Imani Williams failed to move her black Chevy Cruze to the adjacent lane as required by law. Defendant followed the patrol vehicle too closely by making contact with the vehicle and striking it with her Chevy Cruze. Deputy made contact with the driver, the defendant, and while speaking to her, the officer observed a strong odor of alcoholic beverage emanating from her breath. Defendant denied alcohol consumption and stated she was on her way to take her sister home. Defendant explained she dropped her sister off at the lounge and provided the officer with several variations of her story. Officer also observed slurred speech, swaying, and slow stance from the defendant. The defendant agreed to take field sobriety tests evaluations. For the HGN, horizontal gaze nystagmus, the officer observed 6 out of 6 clues. For the walk and turn, the officer observed 4 out of 8 clues. And for the one leg stand, the officer observed 3 out of 4 clues. Officer placed the defendant under arrest for DUI and read her implied consent for ages 21 years of age or older. The defendant agreed to the state administered breath test on the Intoxilizer 9000, which showed a 0.118 reading. And all these events did occur in Fulton County, Georgia. Your Honor, the state is opposed to a signature bond due to the facts of this case. This is not only a DUI, but it also involved an accident, and it it involves public safety, and it also involved a law enforcement officer, Your Honor. And given the fact that she does have a record, she does pose a risk of reoffending while she's out on bond, Your Honor. She has 3 cycles, but that still reflects that she poses a risk of reoffending. And for that reason, Your Honor, we do feel that the bond recommendation of a $9,000 surety bond is appropriate. Nothing further.
Ms. Kim?
Yes, Your Honor. Ms. Williams is 21 years old, actually. She has been here in Georgia for 7 years. She has parents, siblings, and grandma all living together here in Georgia. She has a strong ties to the community, and she graduated from high school with GPA 3.5 and higher. And also she went to Georgia Tech for a few semesters, and she's now working as a dermatologist, medical front desk assistant. So she does not make a lot of money, and this is her first driving incident, actually. So we would like to request for a signature bond, if not maximum $1,000 surety bond, Your Honor. And also ADET, we strongly object to that one, because that is for like a repeated DUI convicted drivers. I don't think that she is qualified for that kind of test. So we just would like to request for signature bond, Your Honor. Thank you.
All right, I'm going to order a $8,000 surety bond. I'm going to order on the first charge of DUI, the $6,000 surety bond. The second charge of driving are following too close to $2,000 surety bond. And then the is my math right? $1,000, I'm sorry. $1,000 on the driving or following too close, and then $1,000 on the improper passing. So that equals 8, 6, 7, 8. All right, so 6, 1, and 1. I will not order the ADT at this time, but no drugs, alcohol, or weapons while on bond. And remember, Ms. Williams, you shouldn't be driving. Your license probably are suspended unless you have a valid driver's license. And DDS, you should not be driving in this interim period while you're on bond. Is there anything else I need to take up?
No, Your Honor. Nothing further.
All right, thank you.
Thank you.
This is position 15, Mr. Towns, and I also have his mother here to speak on his behalf. She would like to say something to the court.
Okay.
Who's this?
15, Towns.
It is.
How you doing, Your Honor?
I'm fine. Hold on one quick second. All right. This is case number 22 CR 001566F. And this is a case of State versus Roderick Towns. You're charged with 1 count of simple battery family violence. And the offense date is March the 8th, 2022. You have anything pre-trial?
24 total. Last arrest was June 2021. Misdemeanor theft by taking, ag assault with a deadly weapon, possession of a firearm during the commission. That's 22 SC 180202. Also has an open ag assault family violence. 21 CP 197454. The February 2021 ag assault, I think that was the same victim. 2018 probation violation. 2015 failure to appears. I got a 2012 criminal damage to property first degree. That was DWAP. 2011 parole violation. 2009 parole violation. He had an ag assault that was dead docket from 2005. 2005 robbery by force, not presented to grand jury. 2004 simple battery that was dismissed.
Okay, I won't go back much further than that.
All right.
Okay, thank you. All right, Ms. Tortorella.
Yes, Your Honor, the state's bond recommendation is a $10,000 cash bond. The conditions is that he have no contact with the victim, and her name is Cassandra Gaines. That's spelled Cassandra. Last name is Gaines. That he take a one-day anger management class, that he stay away from the incident location at 159 McDonough Boulevard Southeast in Atlanta, Georgia. That he have no drugs or alcohol and no weapons and no new violations of Georgia law while out on bond. Your Honor, on March 8th, 2022 at approximately 3:10 a.m., victim Cassandra Gaines came into Zone 3 precinct to report that the father of her child, defendant Roderick Towns, had assaulted her at her residence at 159 McDonough Boulevard Southeast in Atlanta. And this occurred between 12:30 a.m. and 1 a.m. that day. The victim said there was a knock at the door and her 19-year-old son opened the door and it was the defendant on the other side. The defendant came inside and started yelling and calling out the victim's name. The defendant called her bitches and hoes and was wondering why there was someone at her house earlier, like he was watching her home. She then told him she did not want to have any problems because he knows he's not supposed to be around her due to the pending case they already have. She then asked the defendant to leave, but he refused. The victim does not know why and how he was able to come to her home with an ankle monitor. Their 4-year-old son was present during the incident. The victim said that this is when the defendant came towards her, grabbed her by her neck until she was not able to breathe. Victim said that the defendant let go before she lost consciousness and she fell to the floor. The defendant stayed an extra 10 more minutes and continued to call out the victim's name. And then he left and got into a black hatchback. All these events did occur in Fulton County, Georgia. Your Honor, we are very concerned. This case, actually, Your Honor, we are considering transferring up to the DA's office. So this case can potentially be his third felony open case. The 2 felony open cases, like pretrial has stated, is a 21 CP 197454, aggravated assault family violence, which occurred on February 10th, 2021. It involves the same victim in which he struck her with his vehicle. And he's currently in violation of that bond order, Your Honor. And then a 22 SC 180202, he also is charged with aggravated assault, possession of firearm of a convicted felon, possession of firearm during a commission of a crime, and theft by taking. This occurred on May 8th, 2021, in which he pointed a gun and shot at the victim. In this case, it does not involve the same victim here, Your Honor, but it's another victim. He is also in violation of that bond order, Your Honor. Your Honor, also, he's had some violations of probations, including one in 2018 out of Fulton County. He has an FDA on his record. Your Honor, the victim is here and I believe she does want to speak. However, the state does strongly oppose any sort of contact with this victim. Nothing further.
All right. Ms. Kim, do you want to go before or after the victim?
Before, Your Honor.
Okay. go ahead.
Yes, Mr. Towns is 35 years old and he denies the allegations. He believes that this is retaliations of Miss complaining witness Gaines because he filed a warrant against her for ID theft, forgery, and other criminal issues. So there are two warrants that he filed for, and that's why as soon as she found out about those issues, she is making up stories to retaliate him. That's what my client claims. And at this point, he does not live in 159 McDonald at all. And we would like to request for $10,000 surety bond. He has already two children here in Georgia, 17 and 4 years old. He has his mother present there, and he has siblings, niece, and nephew. He's not going to run away from Georgia. He has ties to the community. He's not a flight risk, and he would like to continue his car detailing business that he has been doing. He has a 10th grade education, and even though, because we understand his history, we would like to request for $10,000 surety bond, Your Honor. Thank you.
Your Honor, the state does appreciate the defense's statements regarding the defendant's defense. However, it is not relevant to this bond hearing, Your Honor, as it has nothing to do with the IOLA factors. So therefore, we ask the court not to take that into consideration.
Your Honor, we would like to emphasize that we do not bring up the facts of the other warrants. We just want to have the motivation of the retaliation to be considered. Thank you.
You right there, can she say something?
She got done with her. Thing.
Yes.
Sounds, oh, yeah.
Okay, hold on 1 second for me. Since you want to address the court, I need to swear you in. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes. Okay, good.
All right, and tell me your name again for the record.
Cassandra Gaines.
Okay, and what would you like to tell me, Ms. Gaines, about your son? This is your son, correct?
No, that's his mother that's beside him. That is my son's father. And he right. I lied. He right. I lied.
I'm sorry?
He's right. I lied. And
So you're admitting that you lied to the police?
yes, I lied to the police. I talked to the detective already, and I told the detective that I lied, and he said that I would have consequences behind me lying once we go to court or whatnot. And I let him know that I lied.
And you lied for what reason?
Well, that particular day, we had so much going on and whatnot, and he came back and he was yelling at me, fussing at me or whatnot. And then when he left again, I just was like, you know what, I'm just tired of this. And then I came to the jail, and then I lied.
Came to the jail, or you came to
the Zone 3 precinct.
And you swore out a warrant?
No.
Or I'm sorry, you made a report. I apologize. Right, you made a report and said that the defendant had battered you or touched you or assaulted you, or what did you say?
I just said he grabbed me by my neck.
All right, this is not good. That is not what you're supposed to do.
Your Honor, yeah, please interrupt. Considering her testimony about the lying, we would like to request for signature bond, Your Honor. Thank you.
Your Honor, we object. This is definitely evident of the cycles of domestic violence. And also, Your Honor, she's right. It could be that she's denying right now what's going on. And to add, Your Honor, there is an open pending felony case against the same victim.
it's just too much of not a coincidence.
Don't, hold on, Miss Gaines, do not cut off the prosecutor. Okay.
So therefore, Your Honor, we do ask for the $10,000 cash bond, and that you impose that.
All right, let me hear from his mother who's in the courtroom. And I apologize, yes, tell me your name again. I'm sorry, you all on mute.
Arletha Towns.
Arletha Towns?
Yes,
Raise
ma'am.
your right hand for me, Ms. Towns. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
Okay, what would you like to tell me, Ms. Towns?
That I talked to Miss Gaines earlier this morning, and we also came down here to the jail earlier. She wanted to do an affidavit, but they told her we had to wait until 2 o'clock. And he's already out on a $6,000 bond, cash money. So that don't make sense if she done lied for him to get another charge. That should be dismissed, look like to me, because it don't make sense. Well, I don't have money like that. That don't, because he locked up for something he shouldn't even be down here for. He already on house arrest. So that done created a whole new situation. And it's not fair.
I understand that it's not fair. I am not in the position to determine, although Ms. Gaines states that she did lie, she would have to do an affidavit. She can go back to the precinct where she went initially. Ms. Gaines, are you still on? Ms. Gaines? Okay. Hold on, you're on mute. You're on mute.
I'm still here.
Okay.
Sorry.
Yeah. All right. Well, what I'm stating that is normally under these circumstances, it's not so simple to go and make a false report against someone and then come to court and say, I lied, I changed my mind, I didn't mean it after the person's been arrested. I agree. And I will caution you, Ms. Gaines, the prosecutors and the solicitor's office are listening, and they're here so they can choose to bring charges against you, I guess, if they wish to do that as well. But I am, given that information, I'm going to still go ahead and order a $10,000 surety bond. I'm not going to do a signature bond based on the history and the criminal history and other charges regarding yourself and this defendant. So it'll be a $10,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order stay away from the 159 McDonough Boulevard Southeast. Is that where you live, Ms. Gaines?
Yes.
Okay. Well, he's not to come back there if he gets out on bond. Don't suspect he will anytime soon, but remember that, Mr. Towns, you're not to go back to that address. So that will conclude my ruling on this case today.
Your Honor, and also no contact with the victim.
Oh, I'm sorry. Yes, very important. And no further contact with Ms. Cassandra Gaines. No further contact.
Your Honor, for the record, may I please just address one issue, Your Honor, if you don't mind?
Not particularly. I've given my ruling unless it has something to do with some other conditions that you might have me to impose here.
I just wanted to make sure that did she say that she lied about the previous case as well?
I didn't hear that. She's lied about this case.
That's why I wanted to, can I clarify that part?
You can ask her.
Miss Sandra.
It was just about this. It was just about this case. But I talked to the lady with the family advocate, with the victim's advocate, and she set us up with counseling and stuff. So I don't know like how to go about with no contact if we've been set up with the victim's advocate counseling.
Well, I'm not for sure that the two of you have been set up with counseling. It's probably you being set up with counseling. I'm not for sure that that is the case, that they would set it up for the defendant to come to counseling with you. I'm not familiar with that. course of proceedings. So they've probably set that up for you yourself to get counseling and help, since there are multiple cases with you and this defendant. So
That's correct, Your Honor. The state would provide her with resources for herself as a victim of domestic violence.
Right. Because it appears that you definitely have some incidents going on. So I want to make sure that you're going to be safe, Ms. Gaines, if this defendant gets out on bond at any time. And so that is my first concern, is to make sure that you are safe and taken care of. Okay? So do talk to the victim witness advocate so that you can get some counseling for yourself. Okay?
Okay.
All right. Good luck to you. All right. That concludes this case.
Thank you, Your Honor.
Who do we have next?
Position 11, Mr. Post, he has a private attorney.
Scott Smith.
I'm here, Judge. Good to see you.
Good afternoon. How are you?
Doing well. Thank you, Judge.
All right. This is case number 22 CR 001562A, State versus Kyler Post. Is that? I think I'm pronouncing it right. Kyler.
Yes, Your Honor.
All right. You're charged with 1 count of harassing communications with the offense date of April the 7th, 2021. Do you have anything pre-trial?
Second arrest. Got a 2011 DUI conviction. That's it.
Okay. All right, Ms. Solary, is this your case?
Yes, Your Honor.
Okay.
Your Honor, in this case, on multiple occasions, the victim received messages from multiple fake Instagram accounts that were graphic in nature. The victim also received text messages, phone calls, and voice messages from an unfamiliar phone number that were graphic in nature. And Your Honor, this victim, her name is Kelsey, Kelsey, last name Wingert, Wingert. Your Honor, the victim reported these messages to the police, and after an investigation, it was revealed that the phone number was registered to a Google account. A warrant was taken out, and officers presented the warrant to Google, and they released information regarding the owner. The call record revealed for this phone number revealed at least 19 other victims of harassing communications. After further investigation, it was discovered that the defendant was the person behind the calls, texts, and Instagram messages. The defendant reached out to the victim subsequent to the investigation from the same number, and he apologized for his actions. An officer called the phone number at issue and a male answered. The officer asked the defendant to come to the precinct voluntarily to discuss the investigation, which the defendant agreed. Your Honor, then the defendant admitted to making the fake Instagram accounts, sending the text messages, calling and leaving voice messages for the victim. The defendant stated he came across the victim's profile, but he is a stranger to the victim. Your Honor, for this incident, the state is recommended to keep the bond as set at $200,000 surety with conditions of no contact with the victim and no drugs, alcohol, or weapons while on bond. Your Honor, this defendant is a risk to the community. He has at least 19 other victims. Again, this victim and the defendant are strangers, and his actions show a propensity to cyberbully. Nothing further.
All right, Mr. Smith.
Judge, there's a lot to digest there. Right now, in Fulton County, I've got 9 clients that are charged with murder. The highest bond I have is a $400,000 bond, but the average bond on the murder case in Fulton is $100,000. I've got clients out on $50,000, $75,000 bonds on murder. Nonetheless, Kyler Post, Scott is, Kyler is present before Your Honor. He's 33 years old. He has lived in Georgia his entire life. He attended high school here, college here. He lives here, he and his wife. They're expecting their first child. He owns his own home. He attends First Baptist Church in Snellville, Georgia. He voluntarily appeared at Sandy Springs Police Department, gave an honest statement to law enforcement. The state relays to the court there's 19 victims, yet they only took out one warrant for one alleged victim. He was extremely cooperative, so much so that the officer allowed him to leave the police department and voluntarily surrender himself to Rice Street Jail. Last night, on his own volition, he went to the Rice Street Jail, voluntarily surrendered. He's currently employed. The family relies on him to be employed. $200,000 bond is unobtainable. And his employment where he's been living has been, he's been employed ever since graduating college. Other than that, he has understanding that he cannot have any contact with anybody. In order to get him a signature bond, what I'm proposing to the court is 2 additional special conditions. One is that he does not utilize social media except for work purposes. Secondly, that he attend AA meetings 1 time a week. And that AA meetings that he's going to be doing is because he told law enforcement that when he drinks, he does stupid things, such as what has been relayed as far as the texting or communicating with the alleged victim. And so he's voluntarily going to be attending these AA meetings. So I think the case warrants a sign-on bond, or what is now called an unsecured judicial release.
All right, let me look at one thing real quick. Hold on a second.
And Your Honor, if I may, before you make your ruling.
Yes.
Your Honor, although we appreciate the defendant's voluntariness to cooperate, it's not dispositive of his acts. This defendant does have multiple fake accounts, so he would possibly be hard to keep up with about who he is reaching out to. Also, Your Honor, we are asking for another condition, that's an ankle monitor at the defendant's expense, and that would be for the safety of the victim. We're not releasing the victim's her address due to the nature of this case, so we would ask the court to impose that as well.
So, Judge, if I may respond to that.
Yes.
There's been no direct contact, no indication my client has even attempted to traverse near where the victim lives. And there's not going to be any contact. To provide for an ankle monitor just does not make sense. It's punitive in nature. It goes against the foundation of IALA, which is based upon the American Bar Association rules, stating that pretrial incarceration is punitive, that the least amount of intrusion upon a defendant is what is warranted for the court's consideration for bond. He voluntarily surrendered. So there's nothing else to say other than he is going to appear in court. He's going to adhere to the court's rules. We've already said that he's not going to be on social media other than for the purposes of work. Otherwise, he would sit in jail awaiting trial. So I think that the court's concern over community safety is met simply by the allegations that there's been no contact, but also by us voluntarily agreeing to not get on any type of social media. If Sandy Springs has any indication that any of those are being utilized, then certainly he would be subject to having a bond forfeiture and being rearrested.
Tell me this, Mr. Smith, you mentioned that he's been working at the same job. Did I miss, did you tell me what type of job he has?
I don't mind telling Judge, he's an account executive for a multimedia company. It's a popular multimedia company, and I could put that in the chat if the court desires.
Well, I don't need to know the name, but I was kind of curious when you said do not do social media except for work. And then I thought, well, what type of job does he have that would require him to possibly be on social media? And that was part of my concern, is that this type of conduct stops.
Yeah, no doubt.
Yesterday.
Yeah, I met with him in my office yesterday. where, I cannot force a person to turn themselves in. I know I'm taking up a lot of the court's time, and I appreciate the court's patience. I can't force him to turn himself in. I met with him here in the office. We talked about what was going on, about his to do in order to avoid this from happening again. And he voluntarily surrendered himself. As far as what is required of him with work purposes, I think just, I think that allowing him social media access simply for work purposes would be sufficient, and no personal social media posting or anything to that effect. And that can include, obviously, I could give the court some language such as no social media posting other than for work purposes, and no. If the court can bear with me, I can probably formulate like some more restrictive language.
Need that bond sheet, Miss Holly. Give me a bond sheet real quick for a second. Let me.
Bear with me, Judge. I've got other cases.
Right, I'm looking, as well. On the form bond sheet, it has, again, no contact directly or indirectly with any victim or victim's family member, professional, personal, close associate, whether by phone, mail, email, pager, or any writing, sign, note, or message. So we tried to cover as much as we could. We might need to add a few more stipulations, obviously.
And Your
for
Honor,
bond conditions.
I'm sorry, if I may, I would just like to remind the court that yesterday an ankle monitor was given to a defendant on a criminal trespass. Your Honor, due to the nature of this case, the number of victims, there are possibly more out there. This defendant's lawyer did admit to him having a drinking problem, so we are concerned with any type of interaction with other victims that could possibly result from this. So there is a significant risk to the community, and that's why we're asking for that ankle monitor.
The ankle monitor generally is because we want to track him and make sure that he's not having any physical contact with the victims. I kind of see Mr. Smith's point is that he's not to have alleged to have had any physical contact with anyone. All of his contact has been through the internet and social media. Is that correct?
That's what we have in the police report, Your Honor. But again, it was just a concern because of due to his drinking that the defense attorney did admit these acts could go further than social media or online interaction.
Right. And we have the offense date 4/7/21. I imagine there's a block of messages. I'm assuming they weren't all in one day.
Correct, Your Honor.
So, and again, if he's working, he could probably afford it. So affordability, but I don't want it to seem punitive if we don't have the concerns of him physically contacting some of these victims, or if he's not at this point having contacted them. I mean, he would be on certainly very strict bond conditions as to what I'm looking at this time. I think that I'm not going to do the ankle monitor at this time. What I think I will do, and I'm going to order, is a $75,000 surety bond. I will reduce it to 75,000. I'm sorry, Ms. Bridgewater.
That's okay.
So let's start there. I'm going to do a $75,000 surety bond. I am going to order no further contact with the victim, Kelsey Wingert. He is to stay away from her, I think it's what, 200 yards? and the paragraph that I read with no contact of any sort with any type of internet, social media, or anything, I'm going to order that he not be on there for any personal purposes and very limited for work. I do have a slight concern because if he gets in front of a computer and says I accidentally hit a button and I'm on Instagram, I'm very concerned about it. So
Judge, that would be on him. I mean, if he does that, then his bond would be revoked.
true, but he could contact other victims. I think Ms. Sari is pretty correct, and I can see him saying, well, I won't contact this one, but I've got the other 18 or 17 or how many others. I'm going to wonder and ask if he can do his job without having to get on the internet at all. I understand he's an account executive, and I know we do a lot of work these days by the internet, especially during COVID and things of that nature. But I just don't think I want him on the internet even for work purposes. Emailing is one thing with some of his account customers emailing, but getting on the internet or Facebook or Instagram for work purposes, I'm not so sure that that counts. So, Ms. Bridgewater, I'm going to put in there very specifically, add this condition. He is not to get on the internet other than for email for his job. So there would be no internet for Facebook, Instagram, Snapchat, any of the social media internet purposes, because I don't understand for account management why he might need to get on Facebook or Instagram with his customers. And if he does, well, he's going to have to tell his job right now, I'm going to not be able to do that. I'm going to also order that he definitely continue with his AA program and attend once a week or more, whatever the program requires. I'm going to ask that he have no drugs, alcohol, or weapons while on bond, except for any prescriptions prescribed by a physician. And let's see, is there anything else I need to take up?
One thing I was going to ask, Judge, could you make it to where he's eligible for the sheriff's 10% program?
I don't normally order that. If he qualifies, he qualifies. I leave that to the bonding company.
Well, that way he could pay the 10% to the sheriff and then get that money back, as opposed to have to pay the money to the bonding company and not be able to get it recouped that.
Well, if he intends to show up in court, then he, I don't normally make a habit of doing that. And I'm not going to order it through the sheriff. I'm going to make him go through a bonding company. But Mr. Post, you need to be very, very careful of what you're doing with your computer or phone or however you're contacting these people, because I am concerned that you can contact some new or other persons that this cyber bullying or cyber inappropriate contact that you're trying to have with strangers is getting out of hand. And so I hope that you're ready to stop at this point and not be accused of doing any of these actions, which is why I'm very strictly saying you really don't need to be on the internet at all, in my opinion. Not trying to limit you from being able to conduct or do your job. I think you can do emails, but I don't see why you would need to get on any other internet sources or Instagram to do your job, unless there's something that I'm missing. But I'm also putting this language in to the conditions of your bond, okay?
Judge, can I get a clarification really quickly? Would the court include LinkedIn? I use LinkedIn pretty frequently. It's a quote unquote social network, but it's strictly used for business. Could I get an exception on that to be able to use LinkedIn?
And Your Honor, we would object to him using that site. There was specifically in the warrant, it stated that that was one of the sites he used to target victims.
I was gonna say, I'm very concerned, you know, this that only happened to a few people and, you know, or just one person that you maybe wanted to have a relationship with or something like that. I think that it's embarrassing enough, and I understand, but right now you're on bond. And depending on how your case travels or is disposed of after this, maybe that there can be some readdressing by another judge or the division judge to change some or limit some of the conditions. But I'm going to agree with the state at this point. I'm going to add on here, LinkedIn, I'm going to limit you because that's another source or way to get victims, in my opinion. And so, because you can still go, you know, there's no way, and it's unfortunate, we don't have a way to limit your sources of contact once you're freely on the internet or on these sites with thousands and thousands of people. And until I know that you are getting some assistance or help with whatever's going on with you, if it's the alcohol, then, you know, you just started treatment. I assume you've not been in treatment that long. Until you deal with that problem so that you don't start this over again, I'm concerned about protecting the victims out there and your potential access to any future victims. So I have to make sure that we're doing that. So I'm going to put in here that you are not to no internet, Instagram, or LinkedIn while on bond. Is there any other site I need to list, Ms. Sorry?
No, Your Honor, I believe that was it.
Oh, Facebook. I said no internet,
Instagram.
Facebook, Instagram, or LinkedIn connection while on bond.
That's correct.
Okay. All right. And then no internet except for job and emails. And it's very limited. No further contact with Kelsey Wingert, no weapons, drugs, or alcohol, and continue with the AA program as prescribed. And that is a $75,000 surety bond. Is there anything else I need to take up?
Nothing further from the state, Your Honor.
All right, anything else, Mr. Smith?
No, Judge.
All right, thank you.
Okay, thank you.
Uh-huh.
All right, we're done.
And you may be dismissed, Mr. Smith. All right.
Next, we have position 10, Mr. Lyons.
This is case number 22 CR 001561J. Robert Allen Lyons, your charge is 1 count of DUI, driving under the influence, less safe. 2nd count of driving improper or erratic lane change. And a 3rd charge of distracted driving with wireless or standalone electronic device, all with the offense date of March the 17th, 2022. You have anything pre-trial?
First arrest.
First arrest, okay. All right, Ms. Tortorella.
Yes, Your Honor. For the DUI less safe, we're asking for a $5,000 surety bond. For the improper lane change, it would be a $1,000 surety bond. And for the distracted driving charge, a $500 surety bond. That would be a total of $6,500. The conditions is that he not drive while he's out on bond, that he do ADET, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on March 17, 2022, around 10:51 p.m., an officer D. Wynn, and that's spelled Nguwen, responded to the incident location at Medlock Bridge Road and Prestwick Club Drive in Johns Creek, Georgia, to assist Officer Rolla, and for the record, that's spelled ROLLA, with a traffic stop. Both of these officers are from the Johns Creek Police Department. Officer Rolla advised he observed a red Jeep Wrangler fail to maintain his lane. Officer Rolla further advised the driver identified himself as Robert Lyons and that he appeared disoriented and slow to respond. The officer also observed the defendant fumble around his wallet for his license and that he did admit to the officer to drinking one shot. When the officer Wynn approached the defendant, he admitted to drinking the shot as well. The defendant agreed to field sobriety testing. On the HEN, the officer found 4 out of 6 clues. On the walk and turn, the officer found 5 out of 8 clues. And for the one leg stand, the officer found 3 out of 4 clues. The defendant agreed to provide a breath sample which read positive for alcohol. The defendant was arrested for DUI. The defendant was read the implied consent and agreed to a state administered test of his breath. When at the location for the state administered test, the officer, the defendant refused a breath test and said he would rather have a blood test. The officer reread the implied consent and asked for a state administered test of his blood. The defendant was transported to Emory Johns Creek Hospital, and all these events did occur in Fulton County, Georgia. Your Honor, I understand this is his first offense. However, this is a public safety. We have concerns for public safety, Your Honor, and because of that, we are asking that you impose a surety bond. Nothing further.
All right, Ms. Gant.
Thank you, Your Honor. Mr. Robert Lyons is 56 years old. He completed high school. He has 2 years of college. He is the president of TIPCO Technology. He is in the Atlanta area for business purpose. He is a Maryland resident. However, he does not have any history of FTAs. This is my client's first arrest, Your Honor. He was a cooperative. There were no accidents, and he is recommended for a signature bond. Therefore, I am requesting a signature bond on his behalf. And if Your Honor is not inclined to grant that signature bond, then I would recommend that Your Honor leave the bond as set, and that would be $265 for driving in proper lane change, $265 for distracted driving, and $1,000 for the DUI. And again, we are opposed to any alcohol, drug, and evaluation treatments, Your Honor. That is premature at this point, as my client has not been convicted, and we are opposed to any restrictions on his driving that are not in accordance with DDS. Thank you, Your Honor.
Well, he doesn't have a Georgia driver's license. Is that correct? He's from Maryland. It's a Maryland license.
Yes, Your Honor.
And we do want to make sure, again, he's not from Georgia, that he's going to return from Maryland for court. He did state that he still resides in Maryland, correct?
He resides in Maryland. He also has friends that are in this area as well. College friends from college.
Mm-hmm.
Your Honor, I think that should be considered a flight risk.
He has no prior FTAs, Your Honor. He comes to Georgia for business.
All right, I'm going to order a $4,500 surety bond. That will be $4,000 on the DUI. I'm sorry, that's gonna be, nope, let me redo my math with 3 charges. I'm sorry, doing my math here. $4,500, so that's going to be $3,000 on the DUI, $1,000 on the improper lane change, and then $500 on the distracted driving. Does that equal $4,500?
It does.
All right, so that will be the amount of the surety bond. I'm gonna say no drugs, alcohol, or weapons while on bond. And I'm also going to order that you do no driving unless Maryland's driver service Services suspends his license or not. Just make sure if you do drive, Mr. Lyons, that you have a valid license to drive, but if you don't, then no driving. All right, I'm not gonna order the ADT. Is there anything else I need to take up?
Nothing further from the defense. Thank you, Your Honor.
Thank you.
Nothing further from the state, Your Honor.
Next, we have position 16, Mr. Tupman.
All right, this is case number 22, CR 001567J. Antonio Tupman, you're charged with 1 count of driving while license suspended or revoked. A 2nd count of restrictions on use of blue lights on vehicles. 3rd count of giving false name, address, or birth date to law enforcement. A 4th count of giving false information, and then a 5th count of possession of marijuana less than an ounce, all with the offense date of March 17, 2022. Do you have anything pre-trial?
It's 12th adult arrest. 2019 failure to appear giving false name. 2018 probation violation theft by receiver. 2018 giving false name conviction. 2017 probation violation. 2017 felony theft by receiving, suspended license arrest. 2014 probation violation. 2014 burglary 1st degree conviction. 2014 entering auto arrest. 2013 shoplifting arrest. 2012 FTA.
All right.
Your Honor, the state's recommending for the driving while license suspended a $1,000 surety bond. For the blue lights traffic offense, a $265 surety bond. For the 1st count of giving false information to a law enforcement officer, a $250 surety bond. For the 2nd count of giving false information, a $250 surety bond. And for the marijuana offense, the drug offense, $500 surety bond. That would total $2,265, and that's a good bond. Your Honor, on March 17, 2022, defendant Antonio Tupman did unlawfully operate an Audi Q7, which was equipped with underglow lights capable of producing blue lights at 285 northbound and 166 Atlanta, Georgia. The defendant was also driving with his license suspended for failure to appear while operating said vehicle. The defendant did provide a false name and date of birth of Quinta, and for the record, that's spelled Quin as in Nancy T.A. Tupman. Date of birth, May 5th, 2000, to the officer J. Moore of the Fulton County Sheriff's Office. That defendant did possess less than an ounce, approximately 12 grams of marijuana, and all these events did occur in Fulton County, Georgia. Your Honor, we are not consenting to a signature bond just based on the defendant's history. He has felonies on his record. He's been convicted of burglary, a felony offense out of Clayton County Superior Court on October 20th, 2014, as you heard from pretrial. He's also had a relevant conviction to this case of given false information to a law enforcement officer out of DeKalb County back on August 6, 2019. He also has a recent arrest with no disposition for driving with license suspended out of Fulton County. This arrest occurred on February 17, 2017. And violation of probation and a failure to appear as stated by pretrial. And to add, Your Honor, his license was actually suspended because he failed to appear to a court date. So for this reason, Your Honor, we do recommend the $2,265 surety bond, and that you do not consent to a signature. Thank you, Your Honor.
Ms. Kim?
Yes, Your Honor. Mr. Tutman is 29 years old, and he has been here in Georgia all his life. He has 11 children, from like 9 months to age of 19 years old, and he has parents and siblings here in Georgia. And he has a job as a mechanic. He's been doing that for about 6 months. He graduated from high school. Actually, he got a GED from Job Corps, and he also has a trade skills as an electrical mechanics. Actually, his failure to appear was because he was incarcerated. That's why he could not come to the court. So we would like to ask the court to consider that. And he served his time, and we don't want him to be punished again and again for the same thing that he has done already. And yesterday was his birthday, and he wanted to celebrate with a St. Patrick's Day with a green light, but it kind of became a little bit different. So we would like to request for a signature bond, but if Your Honor is not inclined to give signature bond, we request for no more than $1,000 total. So that's what we would like to request for. Thank you.
All right.
Your Honor, and just to add, the defense did state that his failure to appear was because he was incarcerated. That just goes to prove that he is a risk. He poses a risk of reoffending while out of bond, not only reoffending but also failing to appear to his court proceedings, Your Honor. So therefore, we do ask for a surety bond.
All right, I'm going to order a $2,500 signature bond. That will be $2,000 on the DUI, and then let me see, it may be $2,600. I'm trying to make sure I do my math a little correctly. Help me, Miss Bridgewater. After I do $1,000.
DUI?
$1,000 on the DUI, and then I'll have.
Your Honor, I'm sorry, Your Honor, it's a driving while license suspended.
Yeah,
I'm sorry, driving while license suspended. You asked me that. I apologize. I apologize.
That's
I apologize.
okay. That's what okay.
All right, so 2,500, and let me do my math here. Let's see, that would be then. $500 on each.
Okay, that'll be 2,500.
Right, that'll be easy. I'm trying to do some easier math. 500 on each of the charges, each of the 5 charges, and that would be 2,500 surety bond. Okay, and no drugs, alcohol, or weapons while on bond, and of course, no driving, Mr. Tutman, unless you have a valid driver's license from DDS.
Yes, ma'am.
Okay.
Yes, ma'am.
All right. Good luck to you.
Your Honor, I'm sorry, what was that total bond amount?
2,500, 500 on each of the 5 charges.
That's
surety
a-
bond. Yes.
Surety bond, okay.
Yes. I'm sorry. I'm going to have to brush up on my math a little bit here.
Your Honor, that was a signature bond, correct?
No.
No, surety bond. I'm
Surety
sorry.
bond? Okay.
2,500 surety bond. I apologize. Did I say surety? Okay. Making sure I did.
Your Honor, next we have position number 12, Mr. Jason Rosati.
And Your Honor, I just wanted to bring to the court's attention that the victim in this case is present.
Okay. This is case number 22 CR 001563F. Jason Rosati, charged with 1 count of battery, family violence, and a 2nd count of cruelty to children in the 3rd degree, both with the offense date of March the 12th, 2022. Do you have anything pre-trial?
Counted about 37 total. Maybe it was 27. No, hold on. Yeah, it was 37. Last arrest I got was April 2021 for DUI. 2019 trespass. 2020 FTA simple battery. FTA battery. 2019 simple battery dismissed. 2016 probation violation trespass. 2016 probation violation trespass. Criminal damage to property. 2014 FTA criminal damage to property. 2012 probation violation. He got some more of those. He was arrested in Florida. Last arrest in Florida was 2018 failure to appear. 2018 out of county warrant. 2017 probation violation. Another 2017 probation violation. 2017 DUI conviction. And that's it.
Ms. Tortorella?
Yes, Your Honor. For the battery family violence, the state's recommending a $4,500 cash bond. For the cruelty to children in 3rd degree, a $1,500 cash bond. That'll be a total of $6,000 cash bond. That he do not return to the incident location at 216 St. Andrews Court in Johns Creek, Georgia. That he have no contact with the victim, Michaela, and I apologize if I misspell the last or don't say the last name correctly, Rajat. And the first name is spelled Micaela. Last name is spelled Rajotte. That he take a 1-day anger management class, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on March 12, 2022, an officer L.L. Hasseltine, and for the record, that's spelled Hasseltine, of the Johns Creek Police Department was dispatched to 216 St. Andrews Court in Johns Creek, Georgia. When the officer arrived to the incident location, he spoke with the victim, Michaela Rajat, who said she was arguing with the defendant, Jason Rosati, about him using her money to gamble. The victim advised she began to pack her items for her and her son. A victim is JR, the initials, because she was leaving with her son for the night. Victim then told the accused she was going to contact police and advised that he had spent her money. After that was said, the defendant grabbed the victim by the face and pushed her against the wall.
That is not what I said.
The victim.
Hold on 1
Excuse me,
second.
I'm talking.
Yeah, don't mean to interrupt you, Ms. Rajati. I'm going to mute you and not allow you to address the court. You cannot interrupt the state or any of the proceedings until I've given you permission to talk, okay?
I'm sorry, I didn't know I wasn't muted.
Yeah, go ahead and mute yourself, be on the safe side.
Yes, ma'am.
All right, thank you. All right, I'm sorry, Ms. Tortorella, go ahead.
Yes, Your Honor. After that was said, the defendant grabbed the victim by the face and pushed her against the wall. The victim advised police the defendant had left the scene prior to police arrival. She advised her child witnessed the incident and that she lives with the defendant. Warrants were issued by police against the defendant, and all these events did occur in Fulton County, Georgia. Excuse me, Your Honor. Sorry. Your Honor, the defendant had a case against the same victim, which was dismissed by our office. It was 19 CR 007932D. He was charged with battery and simple battery against the same victim. So this is the second case against the same victim. He's a multi-state offender. He has 9 cycles out of Florida and 28 cycles out of Georgia. He has felony convictions on his record. His last arrest, which was provided to you by pretrial, was a DUI on April 28th, 2021, which he actually pled guilty to in Fulton County State Court. He was arrested for simple battery again, this was the case that was dismissed on September 9th, 2019. And this was the case against the same victim. He's been arrested for criminal damage out of Fort Lauderdale, Florida on 2017, a criminal damage to property, a felony offense out of Johns Creek, Georgia in 2014. He has various violations of probations and failure to appears. And Your Honor, for this reason, we're asking for the cash bond. Mainly, this is the second offense against the same victim. He has 28 cycles out of Georgia, 9 cycles out of Florida. He's committed felonies in the past. He poses a risk of reoffending, and we do feel like a cash bond is appropriate in this case.
All right, Ms. Kim.
Yes, Your Honor, Mr. Rajati. He is 38 years old, and he has been here in Georgia for the last 38 years. He has parents and sister here in Georgia. He works at Atlanta Automax as a salesperson. He has a job here. He also went to high school. He went to college to get associate degree, business manager. So he has a strong ties to the community, and I don't think he is a flight risk. Please understand that 2019 case was dismissed. I don't think he should have. He is. Even this case, he's presumed to be innocent. I don't think he should be punished for the case that was dismissed already. So we would like to request for surety bond instead of cash bond. So that's what we would like to request for. Thank you, Your Honor.
Okay.
Your Honor, as you know, the state doesn't just dismiss cases because a defendant is innocent on the matter. So I just want you to take that into consideration.
All right. Is it Rajat?
Yes, ma'am.
Rajat, okay. Didn't want to mispronounce it. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. What would you like to tell me about this incident?
Honestly, like I'm gonna try really hard not to get emotional here. When I was called about just to be told about the case today for his bond hearing and court hearing, the lady for the victim's assistance, I believe is what it was. I relayed to her that I had tried to be getting in contact with the arresting officer before he actually got arrested on this charge to let them know what had happened. So that night when everything occurred, I was heavily under the influence of drinking, and I did not tell that to the officer. I was pretty drunk and really upset, and I caused that argument. Yes, I was angry and I was upset, but I called the police out of anger, and like what I had told them was that the scratches on my face came from him. But what really had happened was I was so drunk that I tripped and fell and scratched my face on a bunch of glass that I had broken up some dishes that I threw in the kitchen. And that's where that came from. And when they saw it on my face, they just said that he did that. And I just said yes. And the next morning I woke up and I felt extremely, extremely regretful for what I had did. And I wish I wouldn't have did it. And it's not okay to just do things like that. And I take it back. That's exactly the same reason why his last case got dismissed, because I called on some, bogus stuff that didn't occur. And I know that it's not okay to be messing with people's freedoms like this, but at the same time, I was drunk and I apologize. And I would just hope that you guys take that into consideration. And I mean, if I have to suffer any consequences for it, I'm all for it. I don't think you should suffer from my mistake though.
Your Honor, we would like to request for a signature bond based on her testimony, $10,000 signature bond, Your Honor.
Your Honor, we oppose that. We object to that. This victim, again, this is the second time he has a case against the same victim. We are concerned, as you're aware, Your Honor, again, I have to repeat myself, but this is clearly evident of the cycle of domestic violence when the victim becomes in denial of what has occurred or does not want to face the truth. And Your Honor, we do ask for a surety bond that be imposed and that no contact be allowed with this victim as there hasn't, due to like cooling off. We are afraid that this defendant will act up again as he did back in 2019, and he will do so again.
Ma'am, we live together, and I mean that's my son's stepfather. I can't not have any contact with him. Like, I mean, I live in his house, like that 216, that's his house, not mine. So he can't stay away from this location because he owns this property.
And Your Honor, based on that information, we ask for a one-time escort so that he can check that the victim is no longer at the residence.
We would like to ask for no further violent contact, Your Honor, instead of no further contact.
Ms. Rajat, do you have anywhere else that you can go stay for a cooling off period?
No, I don't.
Okay. Are you from Georgia?
No, I'm not. I'm from California. And my grandmother just moved back there recently. I was living with her in Ackworth.
All right, what I'm going to do is I'm going to order a $10,000 surety bond. And I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order no further contact with you so that I make sure that you and your son are safe. And I do find it compelling, even though the other case was dismissed, that again, that wasn't that far away.
But ma'am, I should be the one getting in trouble for falsifying a report. He did not do anything to me. And this is the second time I've done this. That's what I'm not in denial. He has done nothing wrong.
I understand, but my concern again is that you are using very valuable resources for those who need them, and this is the second time. So
right. So if anything, I should be the one getting in trouble, not him.
Well, just like I told the other lady, you would have to go down to the police station, turn yourself in and say, hey, arrest me because I perjured myself and I have filed a false report so that they can bring charges against you. Are you willing to do that?
Does he get his charges dropped?
Not necessarily, because you haven't proven that it didn't happen. And so that would have to go through the legal system. So just like I told the other victim who again wants to say, you know, I lied and I did these things, we can't allow either party to take advantage of the system as well as each other. And so I have to make sure that you and your son are going to be safe. And so this is not too far back from having happened. And like I say, I'm going to order this surety bond of $10,000. I'm going to order a stay away, 216 St. Andrews Court. I'm going to order that the defendant will get a one-time police escort to get his personal belongings.
No, this is his house. See, I'm the one that has to leave, not him. And I have nowhere to go.
And then let me tell you what I'll do. If he goes there and you're there, he needs to leave because he doesn't want to get arrested again, I assume. And so if you move out by the time he's bonded out and gets there, then he can stay there. If you are still residing there, he cannot be there. Well, I'm sure he doesn't want to go back to jail. So then that means you're going to have to find somewhere else to go stay in the meantime until this case is resolved, you and your son.
Well, you're putting us on the street because I have no family out here.
Well, I don't want to do that, but there are some resources through the victim witness assistance at the solicitor's office that can find you some temporary housing to go into until this case is resolved. and to also get you some counseling and some help as well, like I told the other victim in the other case.
So it matters not whatsoever that I don't want to press charges. Like, all this is still happening, even though regardless that I'm saying I do not wish to press charges still. I wasn't even asked if I wanted to press charges. They just automatically did that. Normally when you file a report, they ask you if you want to do that.
Well, who called the police?
I did, but still I was filing a
Okay.
report, not trying to send anyone to jail.
Well, I think the police are skilled and experienced enough to know when there's been some violence, and they want to make sure that you're safe. And so that is their responsibility, their duty, to assess the situation and do what they feel is best for people, sometimes not knowing that you are aware of what's best for you and your son. And you said this child is not by Mr. Rosati, or it is?
No, but is it
Okay.
also best for an officer to lie in a report and state that I said that
Your
he
Honor,
grabbed me by the face
Your Honor.
and pushed me
No,
against the wall
no.
when that's not what was said?
No, because you, and if you need to handle that, then you need to return to the police station for that. So that's all I'm going to do on this case. The $10,000 surety bond. That'll be, let's say, 9,000 on the battery and 1,000 on the cruelty. And so that's going to be my ruling of the court. You all need to govern yourselves accordingly. And, you know, I would say good luck to you, but seek the resources from Victim Witness Assistance Program if you need it, in order to help you with some alternative housing, okay? All right, good luck to you. That's the ruling of the court.
Thank you, Your Honor.
Mhm.
Position 17, Mr. Williams is next.
Okay.
Williams?
Yeah.
This is case number 22 CR 001568Y, Tyrone Williams. You're charged with one count of criminal trespass and a second count of obstruction of a law enforcement officer, both with the offense date of March the 3rd, 2022. Do you have anything pre-trial?
He got like at least 50. Last arrest was 2019. Sexual battery on martyr. 2019, possession of drug-related objects. 2019, trespass conviction. 2018, trespass conviction. He got time served in 2018 for trespass. Got FTAs for possession of drug-related objects, obstruction in 2018. You want more? That's enough.
That's enough. Ms. Tortorella?
Yes, Your Honor. For the criminal trespass, we're asking for a $2,000 surety bond. For the obstruction, a $1,000 surety bond. That would be a total of a $3,000 surety bond. Your Honor, the conditions is that he do not return to the incident location at 7010 Peachtree Dunwoody Road in Sandy Springs, Georgia. That's the North Springs MARTA station. That he have no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on March 3rd, 2022, at approximately 7:40 a.m., an Officer Jay Jackson of the MARTA Police Department was conducting a train patrol detail at the North Springs MARTA station at 7010 Peachtree Dunwoody Road in Atlanta, Georgia, and made contact with defendant Tyrone Williams while on board the train. Defendant was advised that he needed to purchase a MARTA Breeze card, and defendant refused to comply. Then the defendant was advised multiple times he needed to exit the train by the officer, and the defendant refused. The defendant was arrested, and all these events did occur in Fulton County, Georgia. Your Honor, given the most recent arrest that he had and on January 16, 2019, that battery offense that the pretrial stated. I'm about to type it. And Your Honor, given that in his criminal history, 50 cycles, and his criminal he keeps reoffending with criminal trespass, Your Honor. He's had past convictions of criminal trespass in 2019 and 2018 in Fulton County. Your Honor, for this reason, due to public safety concerns, the risk of reoffending while out on bond, we're asking for a $3,000 surety bond. Nothing further.
All right, Ms. Kim.
Yes, Your Honor. This case has a booking error, actually, Your Honor. We we heard this, and we had a bond for the exact same warrant on March 4, 2022. And this is kind of like a repeat again because of booking error that Officer Norris found out today. He has been in jail ever since March 3 until now for 15 days. And yesterday, for the same charge, he already had, he was at SAP calendar on March 17, 2022. He got time served. So we would like to reconsider this, and the time that actually he served in the jail and the mistake that was made, we request for signature bond, and he has been here way too long in the jail, and he should be released, Your Honor. So signature bond, Your Honor.
And explain to me about this error and
Yes.
what we have going on.
Yes. I just forwarded to Miss Tucciarello as well. I got an email from Lieutenant and Officer Norris about the booking error. There were, one was by Atlanta Police Department, and then the other one was for Marta. It was kind of confused. So this one was actually, we already heard this accusation, this warrant already on March 4. At that time, we got $1,500 surety bond, no drug, alcohol, or weapon on the bond. That was the ruling at that day, and that was March 4. He was in jail continuously until yesterday with the same warrant. He was already went through the SAP calendar, Your Honor, and then today it came up again. There was a mistake.
Yeah, Ms. Tartarello, are you able to see if that's the case? Or Ms. Lewis, are you aware of this as well? Or
I'm checking right now, Your Honor.
okay.
Lieutenant Dooley Melinda emailed the difference. And I can also send the notes from March 4.
I'm gonna listen to you turn off my camera for 1 second.
What?
Okay.
Judge, are you there? I found the
I
case
am.
that he pled to yesterday. However, it has an incident day of August 17th, 2021. So I'm not sure what defense is speaking of. I could provide the court with that case number 22 CR 001194Y.
That's correct, Your Honor. That's what I see as well on my end.
So I mean, that would be almost
A totally different case, different victim.
correct. I mean, I can double check to see if he had multiple cases on yesterday calendar, but the only one I see from yesterday is the case number I just provided.
Your Honor, I was reviewing his arrest warrant. Arrest warrant actually says that it happened on March 3rd, and then the accusation that came along with that arrest warrant has different date, August 22, 2021. So there was some kind of like either typo or confusion there. And then what I verified with Officer Norris was that there was actually booking error.
Ms. Lewis, are you looking as well?
Hello?
Yes, ma'am, I am.
Right.
Sorry.
Your Honor, the accusation I filed says March 3rd, 2022.
For today.
I'm checking with records at the jail now, because
Okay.
they're the ones who actually added the warrant.
Okay, please, I would appreciate it.
As Ms. Tortorello just stated, the accusation for today's case is March 3rd. Is that correct, Ms. Tortorello?
That's correct.
And then the accusation date from yesterday's case was August of 2021. It was also a criminal trespass. And I mean, I will be candid, when I put up his name, several criminal trespasses pulled up. So perhaps that's what's causing the confusion.
Right,
but there are two separate dates listed on the accusation from yesterday versus today.
However, he has been here in the jail. It could have been dealt on the same date on March 4 for both of those two charges together. However, it didn't happen. It was kind of like mingled together.
And you're saying he's been in jail since when?
March 3rd. And today is March
Right,
18th.
so that's when he would have been arrested.
On the other case, on the prior case, correct?
Well, I was gonna say, give me 1 second.
Okay.
There is a citation marked for March the 3rd.
Yes, the
2022.
citation number is 1383311, and that's the only citation that we have been continuously dealing. We dealt with that on March 4.
I don't know if anyone can confirm that, Ms. Kim. So I may have to just give him a bond on this for today, if it's a duplicate case. Seeing if the jail or someone can sort it out, but it doesn't appear to be a duplicate case.
No, it doesn't.
It's
Your
not
Honor.
sounding like it is. Yes.
What I see in Odyssey is that his August 22nd, 2021 criminal trespass case was heard on, it was on the March 4th state expedited accusation calendar. So the August 2020, the August 22nd, 2021 case was on that one. And all I see is that this March 3rd case is on for today. I don't see
What
any.
about yesterday? Because I was told that there was same thing yesterday, March 17, 2024, March 3rd, 2022 case. Would you please verify that part? Because March 4, he had a SAP for August 22nd. And then yesterday, he had SAP calendar for March 3rd trespass.
They might have handled them out of turn or out of order, but it doesn't look like it's the same case is what I'm getting at, correct? It's not the same case. One may have come.
That's correct.
Right.
In the case that was resolved yesterday, the 2021 date, he did go to court for it, but that was C calendar. That was not the SAP calendar. And that's per Odyssey.
Right.
I think I see what she's talking about, Judge. According to, probably I can clear up some things. When he was arrested for the expedited accusation counter, it was 3-4-22 counter, and they probably thought that was the accusation or the citation for that particular charge, but it wasn't. It was for an event that happened on August the 22nd of 2021 that they dealt with, instead of the one that we're dealing with now, which is dated 3-4, the date for March. So I think they got vice versa. They accused a charge when he was jailed of a previous charge, and he went on, took a plea on that yesterday instead of the actual arrest that he got arrested in March for. That's just now coming up now.
I got it. Yes, I believe, Ms. Kim, that is the case, not that it's the same case twice, but they may have been out of order, unfortunately. So,
And sorry that this might be out of order, but I'm not sure if your client wants to resolve the case. He already probably took a time served plea yesterday. If he wants to take a time served plea on this and just close out all of his cases, I think this is the last one. I'm willing to extend that offer. Obviously, you have to talk to your client. Sorry to go out of order, but
no, that's okay, Mr. Walker. If we can resolve the case, we're always happy to do that as well.
I mean,
So
he just took a plea yesterday, so I mean, if you want to knock this one out today, I'm not opposed.
And I can take a plea.
Time served, and stay away. And of course, it would run concurrent with anything that he pled to yesterday.
Sounds good to me. No objection, Your Honor.
Okay, do you want to go in a breakout room to just make sure with your client first? Or call down to the jail rather?
I don't represent, actually, I'm sorry, I don't represent clients for the plea thing, so that's something that he has to address.
Who would address?
Mr. Williams.
Oh, you're saying he has to represent himself if he wants to take a plea today? That you all won't represent
I don't
him?
think I do. Am I qualified to do the plea for him? Because I have not had a chance to talk to him about that part.
And that's what I'm saying. Can you call down to the jail to do that?
I'll do
Okay.
that. Sure.
Okay. Ms. Gant?
That's basically what she's saying. She needs to have a breakout with him, Your Honor, to give him some options.
Right. So that he can weigh those. You want to break out or you want to call the jail? Which
I'll
one?
just call the jail. Your
Okay,
Honor.
that might be easier.
Yes.
Okay.
Kim, take a call from me. Okay?
404-612-2392. 404-612-2392. Move over there, Mr. Williams.
Yes, ma'am. Thank you.
Okay. All right, who can we move on with while Ms. Kim is doing that?
We can go to position number 1, Mr. Andrew. No. Is the conflict on? Mr. Kelbaugh? Yeah, there
Yes,
you go.
sir. I am
Position number
available.
1, Mr. Andrews.
Good, thank you.
Let me put it in the chat for her, just in case she didn't catch it.
What position was it, Your Honor?
Number 1. Mr. Andrews, number 1. That's case number 22 CR 001553C. Is this Xavier Andrews?
Yes.
All right, you're charged with 1 count of battery family violence with the offense date of March 16th, 2022. Do you have anything pre-trial?
12 total. 2018 possession of marijuana, theft of services. That's open in state court. 2016 suspended license. 2015 possession of marijuana with intent. 2011 FTA for battery family violence and obstruction. I came off a 2008 battery dead docket. That's it.
Okay. All right, Ms. Sari.
Yes, Your Honor. In this case, officers responded to The incident location, 1033 Hollywood Road in Atlanta, regarding a physical dispute. The officers met with the victim and she advised that the defendant punched her in the forehead while sitting inside of a car. The victim's name is Ashley Matthews, and she is the mother of the defendant's child. Your Honor, this defendant does have a 2008 battery family violence arrest and a 2011 FTA, which we feel will, he presents a flight risk, and he does have a probation violation, so he's at risk of reoffending. Your Honor, this defendant is also a multi-state offender. He has criminal history in Oklahoma, Arkansas, and Georgia. The state is recommending a $3,000 surety bond with conditions of stay away from the incident location, no contact with the victim, 1-day anger awareness course, no drugs, alcohol, or weapon while on bond, and a third-party transfer of the child. Nothing further.
All right. Mr. Kelbaugh?
Yes, Your Honor. We're asking for a signature bond. Mr. Andrews will stay away. He will abide by the no contact order with Ms. Matthews, and he will abide by whatever the court orders as far as the requirements for him to have visitation with his child that he shares with Ms. Matthews. He's 35 years old, Your Honor, and he's a father, not just of the child that the 2-year-old son that he shares with Ms. Matthews, but other children in Atlanta, and he provides for all of them. He's currently working 2 jobs. He has a full-time job at the Walmart distribution center where he's a forklift operator. And he also works a part-time job, also as a forklift operator and warehouse pick and pack person. So he's working these 2 jobs to provide support for his children and for himself. And for those reasons, money is tight, and that's why we're asking for a signature bond. He will abide by the no contact, and with any kind of stay away, he can reside at his brother's house, which is an address that I can provide if necessary. And I see Mr. Andrews raising his hand. However, Mr. Andrews, I would ask you to please remain silent about any of the facts of the case. So for those reasons, Your Honor, we're asking for a signature bond. The battery family violence arrest is very remote in time. The arrest was 14 years ago, and obviously it did not result in a conviction. I'm not sure how it resulted in FTA based on pretrial services stating that it had been a dead docket at one point. And
Your Honor, I'm sorry to interrupt. I just wanted to clarify for the court, I did make a mistake. He's not a multi-state offender. That was for a different defendant. So I would like to retract that from the record.
So pre-trial, or did you see that he has 12 cycles or no? And the last one, there's an open 18 case. I'm just trying to make sure now with his history.
The history is correct.
Okay. Okay.
But no multi-state.
Yeah, because I know you didn't say multi-state, so usually you're pretty good in catching that. Okay.
Sorry about that.
That's okay. Thank you. All right. What I'm going to do is I'm going to give him a $3,000 surety bond. I'm going to order for him to have no further contact with the victim, Ashley Matthews. I'm going to order stay away. I think it was 1033, or did I get that wrong? Hollywood Road.
Yes, Your Honor.
1033, that's correct.
Okay, 1033 Hollywood Road. If there's to be any visitation allowed with the child, that be facilitated. Third-party transfer. I'll allow Mr. Andrews a one-time police escort back to that property if he needs to retrieve any personal items. And no drugs, alcohol, or weapons while on bond. And I believe that will be, is there anything else I need to take out of this case? You sure?
Thank you.
Nothing further.
Judge, you said the bond was 3,000 good bond?
Yes, uh-huh.
Thank you so much.
Flew over. Yeah,
We have position 8, Mr. Kennedy next.
okay. This is case number 22 CR 001570C. John Michael Kennedy, you're charged with 1 count of battery. The offense date is February the 2nd, 2022. Do you have anything pre-trial?
Third arrest. Last arrest was back in June for suspended license. It was dismissed. 2017 out of Alabama, assault and battery 3rd degree. It was found not guilty by a bench trial.
Raise your hand, sir.
I'm sorry, I've never even been to Alabama. That's not me.
Mr. Remain silent, sir.
Okay.
All right. Ms. Sari?
Yes, Your Honor. In this case, the officers responded to the Spice House Midtown restaurant located at 375 14th Street, Northwest in Atlanta, regarding the dispute. Officers spoke with the victim, Jennifer Novak, that's Novak, who is the manager at the restaurant. She stated that the defendant, who is another employee, came into the restaurant on his day off and he ordered food. The defendant then became upset because his bill was not discounted or comped. He began yelling at the victim, and when other male employees defended the victim, he got upset. He started throwing items in the restaurant and broke 3 bottles of alcohol. He also threw a milk crate at the victim, which hit her in the face and caused lacerations. And this entire incident was caught on the restaurant's surveillance. Your Honor, we did hear that history from pretrial, but I also wanted to make a note for the court that this defendant does present a danger to the community. This was an unprovoked attack, and he did commit these acts at his place of employment. Your Honor, the state is recommending a $3,000 surety bond with conditions of stay away from the incident location if he is terminated. Of course, if he is still employed, we would just ask for no contact with the victim, 1-day anger awareness, and no drugs, alcohol, or weapons while on bond. Nothing further.
So Judge, he's correct there. It was South Carolina, not Alabama.
Okay. South Carolina. All right. Ms. Gant?
Thank you, Your Honor. Mr. John Kennedy is 22 years old. He has been in the Atlanta area for 1.5 years. He has family here. Your Honor, we are unopposed to the stay away at 375 14th Street, Atlanta, Georgia. My client no longer works there. Your Honor, Mr. Kennedy has a bachelor's degree in digital marketing. He is currently employed as a trainer for the canvassing team for Brian Kemp's re-election. He has been in that position for about 1 month. Your Honor, my client denies the allegations. He states that he was acting in self-defense against another employee there who had threatened and actually physically assaulted him. He stated that he in fact threw the milk crate. However, he never intended to strike Ms. Novak. He states that he was more so defending himself because he was attacked. Your Honor, we heard about 3 cycles. However, as we also heard that the 2017 assault, he was found not guilty. My client is presumed innocent in this case, and regarding his most recent arrest, that was for a driving offense. So as it stands now, my client does not have any prior convictions of any violence whatsoever. Therefore, Your Honor, I am requesting a signature bond. He is not a danger to the community. In fact, as the warrant states, he was there as a patron of the restaurant. He was attacked, and he definitely has a right to defend himself, Your Honor. And for these reasons, again, I am requesting that signature bond. Again, we are unopposed to the stay away, and we are also unopposed to the no contact with Ms. Jennifer Novak. Thank you.
All right, I'm going to grant a $3,000 signature bond through pretrial. I'm going to order Mr. Kennedy that you stay away from the Spice House restaurant, and I understand you don't work there anymore, so you shouldn't have a problem with that. That's located 375 14th Street Northwest. I'm going to order that you have no further contact with the victim, Jennifer Novak. As long as you don't go there, you won't be rearrested. No drugs, alcohol, or weapons while on bond, unless anything is prescribed to you by a doctor. And I'm going to also order the one-day anger management or anger awareness course at, through pretrial as well, as one of your other bond conditions, okay? Is there anything else I need to take up with this case?
Nothing further from the state.
Okay.
Nothing further from the defense, Your Honor.
All right, thank you. Good luck to you.
Thank you.
Next, we have position 2, Mr. Booker.
This is case number 22 CR 001554J. Monty Booker, you're charged with 1 count of battery family violence, charged with the 2nd count of cruelty to children, and a 3rd count of simple battery family violence, all with the offense date on March the 17th, 2022. Pre-trial, do you have anything?
This is 12th arrest. Previous 11 come out of Pennsylvania. 2019 simple assault, strangulation.
He has
terrorism.
2 cases too.
Oh, okay.
You want to call the other case?
Yeah, I'll call it. Let me call the other case too and let pre-trial finish, and then we can go back to back. And the second case with Mr. Booker is 22 CR 001555J, and you're charged with 1 count of battery family violence with the offense date of December the 18th, 2021. All right, you can go ahead.
12 total.
Trial. Okay.
2019 strangulation,
Excuse me.
simple assault, terrorist threats. They were dismissed out of Pittsburgh. 2019 disorderly conduct, criminal mischief. I don't have a disposition for the DC. Criminal mischief was dismissed. 2015 access device fraud, forgery, bad checks. I don't have a disposition. Well, let me see. Forgery is a conviction. The other charges were dismissed. Got a 2013 simple assault dismissed. Got a drug possession conviction from 2013. Simple assault that was dismissed from 2012. That's it.
Okay. All right, Ms. Sorry.
Yes, Your Honor, in the first case with the date of incident at 12/28/2021, officers responded to 502 Pryor Street Southwest in Atlanta regarding a physical dispute. When officers arrived, they met with the victim in the parking lot, and she advised that she ran out of her apartment with no pants on, just a shirt and a bottom, to get away from the defendant. Your Honor, the victim stated that the defendant became angry with her and he repeatedly hit her in the face and busted her lip, and that was why she ran out of the home. She had blood streaming down her face, and she also said that she was afraid of the defendant. The victim was then transported to the hospital for her injuries. Your Honor, in the second case with the date of incident 3/17/2022, officers responded to the same incident location, 502 Pryor Street Southwest, regarding the victim, the same victim, Laray, L-A-R-A-Y, McGee. Your Honor, this time officers responded, they responded again regarding a physical dispute. The victim called 911 and the physical dispute could be heard over the phone. When officers spoke with the victim, They observed her neck swollen and bleeding. The victim informed officers that her child's father, the defendant, had their child in his hands and he spat on her from a few feet away. The victim then grabbed her son and called the police. The defendant grabbed the victim by her hair, pulled her down to the ground, and while on the ground, the defendant grabbed the victim's neck with a tight grip. The victim did admit she did not lose conscious and she was able to get away. Your Honor, we've heard this defendant's criminal history from pretrial. He did have a 2019 terroristic threat, strangulations, and simple assault that was null pros. But Your Honor, as we've heard earlier today, we would like you to keep in mind that the state does not only null pros charges just because the defendant is not guilty. This defendant does also have probation violations in his history, which present a risk of reoffending. He also presents a risk of intimidating the witness, Your Honor. I do believe she's on the call and she would like to address the court. I'm sorry, the bond recommendation in the first case is a $4,500 surety bond, stay away from the incident location, no contact with the victim, 1 day anger awareness, no drugs, alcohol, or weapon while on bond. And Your Honor, the second case for the BFV, a $3,000 surety bond, for cruelty, $1,000 surety, and for simple battery, $1,000 surety. Same conditions and nothing further.
Ms. Gant?
Thank you, Your Honor. Monty Booker is 31 years old. He is a long-term Atlanta resident. He has family here, including his children that he shares with Miss Lorraine McGee. He has a 5-month-old. He also has 9 additional children. Your Honor, he also pays child support for those 9 children. Therefore, he is really limited in the amount of money that he has to pay toward bond. We are opposed to the stay away at 502 Prior Street, apartment 213. I have been advised by Mr. Booker as well as Ms. McGee that they are both leaseholders at this apartment. Mr. Booker states that he does not have an alternate address. Mr. Booker completed Your Honor, he went up to the 11th grade but obtained a GED. He is currently employed at Midtown Movie Theaters. He has been in that position for the last 40 hours, for the last 5 months, Your Honor. I do apologize. He denies the allegations, Your Honor. He states that with regard to any physical contact with Ms. McGee, he states that he was actually pulling her as she was running with the baby and she was naked. He was more so pulling her to prevent her from running outside. He denies making any physical contact with her whatsoever. We heard a lot about my client's background. However, I would bring to the court in light of what the state said regarding his dismissals, Your Honor, is to rely, as I understand it, on convictions, not on any prior arrest or any dismissed cases, Your Honor, because he is considered, those are not convictions that the court may rely upon. We heard about a simple assault in 2019 that was dismissed. We heard about a matter in 2012, simple assault that was dismissed. We heard about probation violations from the state, but we did not hear of any recency. Pretrial did not bring any probation violations to our attention. And regarding intimidating the witness, this couple has resumed living together. In fact, they never stopped. Your Honor, she has informed me that she wants to have contact and that he helps her out a lot, again, as they are co-parenting. Therefore, Your Honor, I am requesting a signature bond for my client. And if Your Honor determines that he is ineligible, then a bond of no more than, well, he informed me that he has no more than $300 to pay toward bond. So I would ask for $500 for each count if Your Honor determines that he is ineligible for a signature bond. Thank you.
Okay.
As the victim is on the line.
Oh, that's right. I'm sorry. Yes, Ms. McGee.
Yes, ma'am.
Okay. Do you wish to address the court today?
Yes.
Okay, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And what would you like to tell me about this particular incident?
Me and Monte, we've been living together and been together for 2 years. This is my first child, but I am diagnosed and get an income from having post-traumatic stress and anxiety and bipolar disorder. And since I've been pregnant and dealing with postpartum and am pregnant right now, I have been battling with that. And every time that we do get into it, it's either from me trying to self-medicate myself, which is once in a blue moon, but it always ends into a problem like this, or it is right before my appointment, which I have an appointment to get back on my medicine on the 24th. And with having the post-traumatic stress, the first incident that happened before yesterday, I usually run from him when I get him upset, but he purposely tries to separate himself from me, and I taunt him and I was in his face. And both times I even told when I got stitches that I had fell both times because my right foot is broke. It's still half broken, and I'm in my license is revoked because I'm have to get orthopedic surgery and things like that for my foot. So I'm not stable, and I do grab my baby, which he's never in harm's way, but I take him out the house to remove myself due to my own issues. So he's respectful towards me, and I feel like I was taunting him both times. And yesterday was completely sober, but I've noticed that it's when he's going through something that is personal in his life that I can't give him space. And so I run from him because he gets angry, but he never intentionally tries to hit me or tries to make me feel uncomfortable unless it's me.
And Your Honor, if I may address the court.
Yes.
Your Honor, as we've heard today regarding the cycle of violence, this is where the victim, I'm sorry, Ms. McGee, can you mute?
Yes, mute yourself, Ms. McGee. We're getting feedback.
Okay.
Thank you.
Thank you, Your Honor. As we've heard today regarding the cycle of violence, this is clearly the cycle where the victim feels the need to protect the defendant. This defendant is the father of her child. So it's not uncommon that she would recant today. And Your Honor, this is the second incident on record. Note in the first case, she ran out of her home without any pants on. Your Honor, we would like the court to move forward with this. We will move forward with the statements that she gave the police officers and that they used to take out the warrant. And lastly, Your Honor, this court may rely on propensity evidence when granting a bond. And that's why we're bringing up that 2019 strangulation and terroristic threat and simple assault charge. Nothing further.
And Your Honor, if I may, again, we've heard from Ms. McGee. The defense has denied the allegations. We've offered a competing version. There are no prior convictions whatsoever regarding any domestic or battery family violence between these two. It doesn't sound like to me, from what I heard, that she's recanting. She's more so explaining her position, which comports with my client's position. And again, today is about bond. I've established that my client has community ties, that he's not a flight risk, and it's not about guilt or innocence, Your Honor. And further, I would, if I did not make it clear, I am renewing, or either if I'm not, if this is my first time stating this, I am requesting again that there be no stay away, that the court order no violent contact, and if Your Honor is not so inclined, then a third party transfer and one-time law enforcement escort. Thank you.
Okay. All right, I am going to order a $3,500 surety bond. And that will be split with
Are we doing the first one?
yes.
Go ahead and do the second, okay.
Oh, I'm sorry, I didn't tell you. Yes, this is case number 2. I apologize. Yeah, this is case number 2 with the 3 charges. And so the 3,500,
Your Honor,
yes.
I do apologize for interrupting you. I wanted to also bring to the court's attention that according to the pretrial report that I received, he is recommended for a signature bond, Your Honor.
Okay.
And Your Honor, I'm sorry, given this victim's testimony today versus what she gave to the officers the day of both incidents, we would like to reinstate that the defendant does present a risk of intimidating this victim witness.
Now, I'm going to continue with signature bond, given the history and the fact of the 2 cases here today. So the first
I think
case,
you meant to say surety bond, Judge.
I did, surety bond, thank you. We can tell it's Friday, correct? It's been a long week. $3,500 surety bond on case number 2, ending in 1554J. So the first charge of battery, there will be a $2,000 surety bond, $1,000 on the simple battery, and then $500 on the cruelty. Did I do my math right? Okay. All right. No further contact with LaRae McGee. Stay away from 502 Prior Street.
Excuse me.
Remain silent while the judge is ruling. If you have a bond question about your bond condition, I'm happy to speak with you after the hearing.
All right. And there will be a one-time police escort if the defendant needs to go retrieve items from that location. No drugs, alcohol, or weapons while on bond. So that's for the first case. And for the second case, ending in 1555J, 1 count of battery, family violence, I will give a $2,000 surety bond. And again, same condition, stay away from 502 Prior Street. No further contact with LaRae McGee. No drugs, alcohol, or weapons while on bond. All right, does that conclude both cases?
No, Your Honor, I would like to request a third-party transfer for visitation.
Oh, I'm sorry, yes. And let's add third-party transfer on visitation. Thank you for that, Ms.
I still got a question, Mel. I still have a question.
Unless it is about your bond, Mr.
It is about my bond, because if that's the only place I have the gun, she's saying that I live with her and I on a lease and she don't want me to not come over, then why have to I stay away from her?
The judge has ruled, Mr. Booker, she has considered testimony and she has ruled in any statements that you make are not likely to be helpful to your case. And she does have the authority to amend her ruling.
So do LaRae got a chance to still fight to where I could still come see her and be with
Your
her?
Honor, we would object to the line of questioning, please.
Right, and you cannot speak to the victim at this time. That line of questioning is not proper, Mr. Booker. I have ruled
But
that
my question is, what if she's willing to speak to me though?
Mr.
You cannot, I mean, well, you need to be careful because you're gonna end up right back here in the Fulton County Jail. You're not to go around her, you're to stay away from her.
Excuse me, with all due respect.
Mr. Booker, please remain silent. The judge can actually modify your ruling that is not in your favor. I advise you to remain silent, sir.
No, I'm allowed to speak for myself, right?
Not really, you have an attorney representing you.
Okay.
You defer to your attorney and be very careful. The state is listening. And I think where your line of questioning is going is if she comes around you, you need to run, go the other way.
No, but what we were just talking about on the camera, she said everything that we didn't really have a problem like that. And now you're making it to where I can't go around that.
But guess what? You have 2 cases on the calendar today with the same victim, 2 separate incidents.
But she just explained both of the incidents.
But that's for trial. This is a bond here.
Exactly.
Okay? So
But
remember what
how
this
can I
is.
go around her?
Mr. Booker,
You need
remain
to stay
silent.
away. You need to stay away or else you'll just be right back to jail real quick. You've got to stay away. Find somewhere else to live and stay away.
Yes, ma'am.
Okay? Be careful. All right. Good luck to you.
Next, we got petition 5, Mr. Caldwell. Come on, Caldwell.
This is case number 22 CR 001557 C. Sabree Caldwell. You're charged with 1 count of cruelty to children in the 3rd and a 2nd count of battery family violence with the offense date of 3/17/2022. Do you have anything pre-trial?
12 total. He got open cases. Trespass, reckless conduct, 21 CR 004502 C. 22 SC 181247. That's for criminal damage to property, battery on a pregnant female and cruelty to children. That's it.
All right. Ms. Salary.
Yes, Your Honor. In this case, officers responded to 6442 Gray Fox Way in South Fulton, Georgia, regarding a physical dispute. When officers arrived, the victim, Raven, Raven, Ager, Ager, advised that she caught the defendant cheating on her at a club. When the victim confronted the defendant with this information, he became angry and punched her in the face. The victim was holding their 1-year-old daughter at the time. Your Honor, the defendant then choked the victim, but she was able to hit him with an object to escape. And the victim then ran outside with their child and called for help. Your Honor, we've heard from pretrial that this defendant does have 2 open cases, the first being the reckless conduct and unauthorized discharge of a firearm. However, Your Honor, the 22 SC case is a battery family violence against the same victim. He was given an $11,000 straight bond, and he was given specific bond conditions to stay away from this victim and stay away from the incident location. So he has violated his bond conditions, which we will file that motion to revoke. The state is recommending a $5,000 cash bond with conditions of staying away from the incident location, no contact with the victim, 1-day anger awareness, and no drugs, alcohol, or weapon while on bond. Nothing further.
All right. Mr. Kelball.
Yes, Your Honor. Mr. Caldwell is 29 years old. He shares a child with the alleged victim. He also has other children in Metro Atlanta. He works as a lead at a bottling plant for Coca-Cola, and he's worked there for nearly 5 years. It's a good job, and he needs that job in order to pay support for the child that he shares with the alleged victim and for his other children. This incident arose because he foolishly went over there to exchange custody of the daughter, when, even though I say foolishly, because he was supposed to be using a third party to exchange custody. And because of the hours that he works, it's difficult for him to sometimes find a third party to do that. So went over there himself, and as you heard, the origin of this dispute was that the alleged victim thought he was cheating on her. He Mr. Caldwell has several children to support and a good job, and we're just asking for an opportunity, a reasonable surety bond so that he can bond out. And he has learned his lesson and will not have any contact with Ms. Caldwell, with the alleged victim directly. I would ask for a $3,000 surety bond with no contact and a third-party transfer. And if he violates that, Your Honor, then he would obviously be back in jail. And I would also add that he's in the process of getting on child support for the child that he shares with the alleged victim.
Okay. All right, I'll order the $3,000 surety bond. I'm going to order stay away from the incident location at 1225 South Fox Way. I'm gonna order no further contact with the victim, Raven Adger. I'm gonna order third-party transfer for visitation with the child. And I don't know if Mr. Caldwell needs a one-time escort back to that location to retrieve any personal items.
No,
He's shaking his head no.
No, okay, then we'll take that out of the order, Ms. Bridgewater.
Okay.
No drugs, alcohol, or weapons while on bond. And I think that's all I need to address in this matter. Anything else from either attorneys?
Oh,
Oh,
cruelty charge.
I'm sorry. It was two charges. So
Yes.
2,500 and 500, so
Okay.
it equal 3,000. I apologize. So that's $3,000 signature bond for both. I'm sorry, surety bond, surety bond, surety bond. Surety bond.
Thank you, Your Honor.
Total bond is 3,000.
Total bonds 3,000, yes. 2,000 on the battery, 2,500 on the battery and 500 on the cruelty. 25 and 5. All right,
Thank you, Your Honor.
thank you.
Next, we have position 9, Mr. Kurtu.
Good afternoon.
This is case number 22 CR 001560B. Mr. Kurtu, you're charged with 1 count of battery family violence and a 2nd count of criminal trespass, both with the offense date of October the 29th, 2014. Pre-trial?
39 total. Got history out of Florida, Massachusetts, and Rhode Island. Last was back in March 2021 for assault and battery out of Massachusetts. I'm gonna go out of order. 2018 out of Florida, probation violation, grand theft, credit card forgery conviction. 2017, 2015 fugitive from justice warrant for domestic violence. Ag battery 2013 dismissed. No, that was 2014 dismissed. 2011 probation violation. This is the Florida history. That 2021 assault and battery, that was dismissed, FYI. 2019, he had a arrest for negligent operation of a motor vehicle, that was dismissed. 2018 larceny. 2018, it says unknown. 2015 assault and battery. 2015 fugitive from justice. 2017 out of Rhode Island for theft, obtaining a credit card. I'll leave it at that.
Okay. All right, salary.
Yeah, Sharon, I'm sorry, just one moment. I'm
Okay.
pulling it out.
Okay.
Your Honor, in this case, officers Officers responded or were called out regarding a fight between the victim. Her name is, I'm sorry, it's WAFAE, last name BALZOURT. Regarding the dispute with the defendant at 261 19th Street Northwest in Atlanta. Regarding the physical dispute, Your Honor, the victim advised that the defendant smashed her cell phone and that he also struck her and caused injuries. Your Honor, the victim and the defendant do have a child together. This defendant lived in Florida at the time of this incident, and that's why it's a 2014 case being brought forward today, because he was out of the state when after this incident occurred. So he was not able to be prosecuted because he was out of the state. So being that he is here today, we are going forward with the charges. Your Honor, the state is recommending a $3,000 surety bond with conditions of staying away from the incident location, no contact with the victim, a third-party transfer of the child, a one-day anger awareness course, and no drugs, alcohol, or weapon while on bond. Nothing further.
Ms. Gant?
Thank you, Your Honor. Mr. Marwin Kurtu is 31 years old. He has been in the Atlanta area for 2 years. He shares 3 children with Ms. Balzort. He has 2 twins and 1 8-year-old. He is has completed high school, Your Honor. He is unemployed and has been so since the onset of the COVID pandemic, Your Honor. So therefore, he will not have the means to pay much, if anything, toward bond. We are unopposed to the stay away at 261 19th Street Northwest. Furthermore, he advised that he has not been in contact with Ms. Balzort for at least the last year. We are unopposed to the third-party transfer order. And Your Honor, for Mr. Kurtu, I am requesting a signature bond. We heard a lot about his background, but we also heard that those violence convictions were dismissed, Your Honor. If the court is not inclined to grant a signature bond for Mr. Kurtu, I would ask for a bond of no more than $1,000 for the battery family violence. Thank you, Your Honor.
I'm going to order a, I don't think you can ask me questions. Let me give my ruling first, Mr. Kurtu. I'm going to order a signature bond through the jail. And it will be in the amount of $3,500, $3,000 for the battery, $500 for the criminal trespass. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order no further contact with the victim, Ms. Balzort. I'm going to order stay away from 261 19th Street Northwest in Atlanta, and third-party transfer for the visitation with the child. And I think that's all that I'm going to do for today.
Yes, sure.
What type of bond is it, Judge?
Signature bond through the jail.
It's been
3,500 signature bond through the jail.
It's been 8 years, Your Honor.
It's a signature bond, Mr. Kurtu. You will be able to sign yourself out on your own recognizance.
And Your Honor, also, this was our concern because, as the defendant stated, it has been 8 years. It has been that long because he fled the state after this incident. So we were concerned about him appearing for court to answer for these charges. So is there a way he can be monitored? That way we keep a toll on him?
Your Honor, we are opposed to any monitoring. He has returned to the jurisdiction and has been here for the past 2 years without incident.
Your Honor, we're asking for at least monitored through pretrial.
I can order it through pretrial per judge.
Thank you, Your Honor.
The multi-state offender. That's why you're not recommended.
The report that I received is that he's recommended for a signature bond.
He's recommended for the jail, not
The
pretrial.
jail.
He's multi-state. That's what I'm saying.
Thank you for the clarification.
Oh, thank you for the clarification. I will, I'm sorry, Ms. Suri, let me go back to my original ruling, pretrial through the jail. I apologize.
What's the
Again,
ruling?
signature bond through the jail. I'm not going to do it through pretrial if you tell me it doesn't qualify as a multi-state offender. I had ruled a $3,500 signature bond through the jail.
Thank you, Your Honor.
3,000 on the battery and 500 on the trespass.
Thomas, come on. Position 13.
Thank you, Your
Mr.
Honor.
Saunders is next.
Excuse me, Judge, can I, apparently, the position that's gonna take a plea, I just wanna know at the jail if Deputy Elton was available to check his email to get the plea paperwork for the individual to sign.
Yes, he received it.
Okay, thank you. I just want to clarify, make sure they got it.
Thank you, Ms. Lewis. Appreciate that. Who do we have next?
Position 13, Saunders.
22 CR 001564H, Christopher Scott Saunders, the charge of 1 count of battery family violence, offense date November 18, 2020. Pre-trial. You're on mute. Oh, maybe you know that.
This is third cycle. In 2016, he was cited for wrongful use of marijuana in the Army. 2019 Texas possession of marijuana conviction. That's it.
Okay. Ms. Tortorella.
Yes, Your Honor. For the bond recommendation for the battery family violence is $5,000 surety bond. The conditions is that he do not return to the incident location at 2367 Cascade Road Southwest, apartment B as in boy -5, Atlanta, Georgia. That he have no contact with the victim. Her name is Destiny Coleman. Traditional spelling for both first and last name. That he take a 1-day anger management course. No weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on November 18, 2020 at 9:49 p.m., an Officer M. Smith responded to a fight in progress at the incident location, 2367 Cascade Road Southwest, apartment B5 in Atlanta. Upon arrival, the officer spoke to the victim, Destiny Coleman, who advised that her and the defendant, Christopher Sanders, had left the apartment to walk to the Family Dollar and get some diapers. The victim said that while at the Family Dollar, the defendant started making a scene at the store about the diapers. The victim further advised that they came back from the store without the suspect and locked him out of the apartment around 7:20 p.m. The victim said the defendant returned to the apartment and started beating on the door to get his things because the victim wanted him to leave. The victim said she let the defendant in to get his things and started getting angry over his belongings. The victim further stated that after she advised the defendant that they were done, the defendant grabbed the victim by the throat and pushed her to the bed and began beating her all over. The officer observed swelling and redness to the right side of the victim's face, and the victim and defendant lived together. The warrant was issued against the defendant, and all these events did occur in Fulton County, Georgia. Your Honor, like you heard from pretrial, he is a multi-state offender. He has 1 cycle out of Texas. He was arrested in Virginia. He has a cycle there through the U.S. Army jurisdiction. And the 1 cycle here, Your Honor. This happened almost 2 years ago, and the defendant just got arrested for this. So there is concern in that regard as far as flight risk. And then the violent nature of what has occurred here, Your Honor, is also concerning and goes to the intimidating the witness here, the victim. He knows her, he knows where she lives. So for that reason, Your Honor, we are strongly opposed to a signature bond in this case. Nothing further.
All right, Mr. Kelbaugh.
Yes, Your Honor. Mr. Saunders grew up as an Army brat. That's his words, not mine. But he grew up as a child of people who were in the Army, and he also eventually, so he moved around a lot. But he finished middle school and high school in Atlanta. Did 1 year of college at Embry-Riddle Aeronautical Institute, but unfortunately had to leave college there because of finances, and he joined the U.S. Army, where he served for approximately 3.5 years. Obviously, when you're in the Army, you don't have a choice of where you go, and he made, I guess, some bad decisions while he was in the Army that resulted in those 2 cycles that pretrial has mentioned. But that was done at a time when he was serving our country. This incident, my understanding is that this incident, as Madam Prosecutor said, it happened almost 2 years ago or 1.5 years ago. He only found out that he had this warrant a couple of days ago, and when he did find that out, he turned himself in voluntarily, which is the strongest possible indication that he is going to stay and return to court and do the obligations that he has to do. Another indication is that in that time, since this incident, there's been no other arrest. He has nothing else on his history other than these 2 marijuana arrests. Your Honor, we're asking for a signature bond. He works here in Atlanta. His mother lives here. He can stay. His mother lives in Locust Grove. I have spoken to her, and I have her address. I've confirmed that he can stay with her. And if Your Honor so orders, we're asking for a signature bond. And if he's ordered to not have contact with the alleged victim, then he will comply with that request. Mr. Saunders, do you have a question? I would advise you to.
Yeah, I've never been to Virginia, so I've never been arrested in Virginia. That's all I have to say.
Okay. Your attorney can check on that for you afterwards.
Your Honor, I understand that the defendant has served our country, and he's done some good things. However, just looking at this case, Your Honor, this involves putting his hands around the victim's throat and then beating her all over. And for that reason, we do ask for a surety bond in this case, Your Honor.
Okay. I'm going to order a signature bond through pretrial in the amount of $5,000. I'm going to order a stay away from 2367 Cascade Road, Southwest, apartment B-5. No further contact with Destiny Coleman, and a 1-day anger awareness course, and no drugs, alcohol, or weapons while on bond.
Your Honor, may he have one trip to get his belongings from the?
Yes, and a one-time police escort to our law enforcement escort to get your belongings if you have any still at that location. Not go back without a police escort, okay?
Yes, ma'am.
All right. That should conclude this case.
Thank you, Your Honor. That concludes my business. May I be excused?
Yes, you may. Have a good weekend.
Thank you, Your Honor. You as well.
Next, we have position 14, Mr. Thomas.
Okay. This is case number 22 CR 0015 65Y. Trevion Thomas, you're charged with 1 count of carrying a concealed weapon. The offense date is 3/17/2022. Retrial.
First arrest.
Okay. All right, Ms. Tortorella.
Yes, Your Honor. One moment.
Okay.
For a carrying concealed weapon, we are asking for a $3,000 surety bond. Conditions is that he have no contact with his partner, Justin Roberts Gotel, who was also arrested in this case for felony. The last name is Roberts hyphen, and it's Gotell. First name's Justin. That he have no contact with that person, no weapons, no drugs or alcohol, an alcohol drug evaluation and treatment, and no new violations of Georgia law. Your Honor, on March 17th, 2022, an Officer Pectol, and it's spelled Pectol for the record, and Officer Durmishi, spelled Durmishi, of the Atlanta Police Department were conducting surveillance at 24060 Martin Luther King Jr. Drive Southwest in Atlanta, Georgia. The officers observed possible illegal drug activity at the location. The officers observed a green Dodge Charger that was heavily tinted and observed that the driver remained in the driver's seat with his vehicle on and continued to have individuals approach the vehicle and contact the driver. The officers also observed a black male with long twists in his hair, wearing a gray puff jacket, continue to enter the passenger side of said vehicle and spend a brief amount of time in the vehicle and then exit again. The male with the gray puff jacket would continue to reach into his right pocket of the jacket and into the left inside of his jacket when people would approach him. As the officers continued surveillance, they observed that the male with the gray puff jacket was approached by a male and 2 females, and the group began to smoke suspected marijuana with each other. The man with the gray jacket remained with the group smoking. While the officers continued to conduct surveillance, they observed a patrol vehicle enter the parking lot and the group dispersed. The officers observed the male with the gray jacket enter the green Dodge Charger again. The vehicle reversed out of the handicapped parking lot, and it was in and parked at a different parking spot. After the patrol vehicle left, the officers observed the male with the puff gray jacket reach under the passenger seat in attempts to conceal an object and proceeded to the food mart while the driver entered the barbershop 3 doors down. Officers then entered the parking lot, and they entered with other units, including a canine unit. The canine unit did perform an open air search because officers did smell odor of marijuana. Officer Pagan and his canine partner deployed, at which both males exited the establishments. Once the driver saw the canine, he attempted to get to his Dodge Charger, at which point the officer and canine were in front of the driver's vehicle. The driver then turned around and entered the barbershop, and the male with the gray puff jacket entered touchdown wings at the plaza. Officer and the canine began performing an open air sweep, at which time Canine Jumbo gave a positive alert on the driver's side of the Dodge Charger. Units entered both businesses and detained both subjects. Officer identified the man with the puff gray jacket as defendant Trevion Thomas, who advised officers he had backwoods and some money. Officers found a firearm, a Glock 19, on the left side of his jacket. Search incident to arrest. Defendant was arrested, and all these events did occur in Fulton County, Georgia. Your Honor, I understand this is his first cycle. However, the person he was with, currently his case is in the DA's office at Superior Court. Justin Roberts Gotel was arrested for the same incident, but charged with felony possession of meth, possession MDMA with intent to distribute, and the case number is 22 CP 207534. We're not okay with the signature, Your Honor. We can infer from the facts and that what his partner was charged with, that he was participating in sale and distribution of illegal drugs. However, the state only had enough to charge his to charge this defendant with the weapon charge. Nothing further, Your Honor.
Your Honor, Mr. Thomas is 18 years old, actually. He was born in 2003, September 9. He's only 18 years old and he has the last semester at high school. He needs to go back to school. He does not have a job. He's still a student. And he lost his mother about 5 months ago on October 12, 2021. And he only has an older sister who can help him. So there's no way that he can pay for any kind of signature bond at this point. So we would like to request for a signature bond, considering the fact that this is his first ever being in trouble. And he wants to be a graphic designer and he has a dream to pursue. I think the wisest thing to do is for him to go back to school. Thank you, Your Honor.
I am concerned regarding the facts of the case, or the allegation, should I say, and the carrying of a concealed weapon at 18 years old. Not a good way to start life. And I know that Ms. Kim is going to tell you, Mr. Thomas, not to say anything because it could be against your interest. Do you have a question? No? Okay. All right. And I'm assuming, Mr. Thomas, you reside with your mom. Your mom has passed, so who do you reside with?
Sister, 25 years old.
What high school do you go to? You know, Ms.
I do
Kim.
not know, Your Honor. We have to ask him.
What high school?
Mr. Thomas, what high school do you go to?
I go to Cram High School now.
Are you on track to graduate?
I am, but if I don't miss almost 3 days, going on 3 days, that's gonna set me back a little bit, but I'm still am.
Does your, I know that you don't work. Does your sister work?
Yes, but it's only part-time. It's just so she can keep the rent and stuff covered at home. The rent and the power covered at home now.
She have children?
No, ma'am, on her. Well, yeah, no, ma'am, on her child. I'm sorry.
Ms. Tartarello, I believe 18 is the age to sign themselves out of jail, or no? I was gonna ask pretrial, but I think gone.
Your question.
Oh, you're there. I'm sorry. I apologize. I thought you were gone. Can he sign himself out at 18?
Through the jail, yes.
Mr. Thomas, I'm very, 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 very reluctant. And I am very, very, very concerned about your conduct and what you're alleged to have done.
But I get what they said, but how could they say I did anything?
Mr. Thomas, would you please?
I really wasn't asking you
silent.
to answer anything. You need to be very careful.
Your Honor,
to not
he's
affect your
presumed
case.
to be innocent.
Okay, so I'm going to give you a signature bond very reluctantly. And I hope that you don't mess up and come back, okay, while you're on bond.
Yes, ma'am, thank you.
And it's gonna be a $5,000 signature bond through the jail. So you can sign yourself out,
How much did you say, Joe?
5,000. Because if you get into any more trouble and forfeit and come back, it'll be a $5,000 fine. No further contact with Justin Robert Spiltail. No drugs, alcohol, or weapons while on bond, unless you have medication prescribed by a doctor. And I'm gonna add one other condition. You must go to school. You must go back to Crim, get yourself back in.
I'm still in, but I just missing days, you know what I'm saying, because I was in.
Well, you got a lot of homework to do, a lot of makeup work to do. You can do it.
Thank you.
Okay, I want you to get that high school diploma.
Yes, ma'am.
Your Honor, can you impose a curfew on him since he's still in high school?
Yes, very good. I shall. Thank you for that. I'm going to impose a curfew. You need to be in by 10 p.m. on a school night, 11 p.m. on the weekend. And you can't go out before 7 a.m. What time do you have to be at school?
So I gotta be there at 8:30 in the morning.
Okay, do you leave about 7 a.m.?
Yeah, ma'am.
Okay. How do you get there? Public transportation or your sister takes you?
See, sometimes I have my grandma Uber me there.
Oh, okay. All right, so you've
Sometimes
got
I
resources. Okay, so you have resources to get to school. So 7 a.m. So you'll be in the house on the weekdays from 10 p.m. to 7 a.m. and on the weekends from 11 p.m. to 7 a.m. Okay? So I want you to adhere to those curfews. If you get picked up or somebody, you're with the wrong crowd or you get in trouble, you're going to jail. So you better be very careful about who you hang out with too.
Yes, ma'am. Thank you.
Okay? All right, good luck to you.
All right.
All right.
Position 17, Williams.
We still miss, is that Mr. Tyrone Williams?
Yes, is this
I'm missing the plea and verdict form.
right?
There was only two pieces of paper, was the plea statement and the waiver, but I don't see the plea and verdict form.
Honor, I just.
Solicitor, did you send out the plea and verdict form?
Just send it.
Like the one that you have to sign?
Your Honor, I just sent it to Miss Bridgewater and Miss Lewis. It's in the attachment, it includes the waiver form of counsel and the plea forms.
Yeah, I already had the waiver form.
What happened with Collier?
Oh no, that's a waiver on a different case.
And Your Honor, I'm
Yeah.
sorry. Good evening. This is the court
Good evening.
reporter.
Yes.
Hi. This is the one that I need to take down, correct? Position
Yes.
17. Okay,
Position
thank you.
17. I have a waiver on position 4. But we'll go ahead so our court reporter can go. Let's do that one first. And then you all, Deputy, do you know what happened to position 6, Julius Collier? Did he bond out? Bond out?
It's bonded out.
And is that, do you have Alex Bross or Brausc? Oh, that's the waiver. Okay, all right. All right, you, Mr. Tyrone? I'm sorry. Yes, Miss Young? Which case?
I'm
are you here for?
supposed to be here for the Collier case because he had robbed me.
Hold on,
and
hold on. Just tell me which case, that's all. Don't tell me anything else. He bonded out, ma'am. So you're to be released. You're the victim in that case?
Yeah, because
Okay, hold on. I'm on a time crunch a little bit. What I need you to do is to contact the solicitor's office, the victim witness advocate, and they will give you the updated information about the case and him bonding out, okay? Is that correct, Ms. Sorry?
Yes, Your Honor, that's correct. We'll be in touch with her.
Okay?
Sorry about
So
that.
stay calm. We apologize. Didn't know you were there from earlier, didn't know what case you're on, okay?
Okay, thank you.
Okay, they'll provide you with some resources, so contact the office, okay? All right. Okay, I'm sorry, Ms. Lopez. Mr. Tyrone Williams Jr., correct?
Yes, ma'am.
This is case number 22 CR 001568Y. And you're ready to take a plea, is that correct?
Yes, ma'am.
All right, I want to first warn you again, anything that you state about the facts or occurrences of your case can and will be held against you, so govern yourself accordingly.
Yes, ma'am.
And also, I need you to raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, state, do you stipulate to the venue, identity, and factual basis?
Yes, Your Honor.
Oh, I'm sorry, and I forgot, he's representing himself. Do you choose to go forward with this plea representing yourself, Mr. William?
Yes, sir. Yes, ma'am. I apologize.
Okay, and you understand the risk in that, but it, you're representing yourself,
Yes, ma'am.
okay? So it's my understanding that you wish to plead guilty to 1 count of criminal trespass and 1 count of obstruction of a law enforcement officer, is that correct?
Yes, ma'am.
Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied? Well, you're representing yourself voluntarily, is that correct?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving your right to the presumption of innocence?
Yes, ma'am.
Do
And
you
Your Honor,
understand?
I'm
Yeah.
sorry, Your Honor, before you proceed, I just want to make sure the defendant is aware. So for criminal trespassing obstruction charge, it would be time served, but we're asking if you could add balance suspended and that he stay away from that MARTA location.
Okay, gotcha. Stay away. Okay, thank you for clarifying that with the plea. I appreciate it. All right, and do you understand that by pleading guilty today, you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And do you understand that you are voluntarily prepared and agreeing to waive these rights today?
Yes, ma'am.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of a guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And as to the charges of criminal trespass and obstruction of a law enforcement officer, how do you plead?
Guilty, ma'am.
Okay, and so you understand that this is going to run concurrent with the plea that you took yesterday, 12 months to serve, credit for time served, balance suspended, runs concurrent. The conditions are that you will stay away, and it's very important, from the North Springs MARTA station at 7010 Peachtree Dunwoody Road. You're not to go back to that station while you're on probation.
Probation.
I'm sorry, it's balance suspended, but you are to stay away from that location. And that would be for what length of time, Ms. Tartarella?
It'll be 12 months.
The full 12 months.
Concurrent for each charge. Yes,
Right,
ma'am.
concurrent for each charge, running with the ones that you pled guilty to yesterday.
Yes,
So
ma'am.
it is 12 months that you need to stay away from that location, or else you'll be locked up and start all over again.
And Your Honor, just to put on the record, this case is, this plea is going to run concurrent to his the other case he pled to. It's 22 CR 001194Y.
Thank you for that clarification. I appreciate it.
Thank you, Your Honor.
So do you understand the conditions, Mr. William, of your concurrent guilty plea today to these 2 charges?
Yes, Your Honor.
Okay, so you've got to Uber, take ride shares, or get off before the train goes to North Springs, because they will see you there at MARTA and lock you up again very quickly. They're
Thank
very
you.
serious about it. So don't slip up and do that.
How many days? has it
Understood,
been?
ma'am.
And how many days has he served, Ms. Tartarella? Looks like 9.
Hold on, let me double check, Your
Okay.
Honor.
I need to know all of that.
Right.
Is Ms. Lewis, can she hear me?
Ms. Lewis?
Yes, I can hear you.
That sentence sheet,
I did send it, Miss Holly. Check your
I
email.
don't see it. Okay, I'll look again. I don't
It's,
see
it,
it.
it's, I just sent it out again. I just sent it to you.
15 days.
Okay, let me look.
Your Honor, he served 16 days.
All right,
Okay, 16 days.
16
okay.
days, that is correct. So you're getting credit for 16 days.
Okay.
Yes, it'll be 12
I
months,
don't
served,
see the sheet.
16 days credit for time served, 16 days balance suspended.
Thank you. Couldn't have said it better.
Sorry.
Also,
No,
Ms.
that's good.
Toretto,
I had it, thank you.
Yes.
Oh, I'm sorry. I
I'm
had
sorry,
it.
Ms. Toretto, there was 3 parts of that plea package. I only saw 2. The plea and verdict is the
Oh,
form
that
that
one
you have
sheet.
to sign. Did you
Right.
sign it and give it to him to sign? It says when he circled guilty, not the plea statement, the plea and verdict, where you put the charge and he put his signature and said, I plead guilty on this day, and his signature, and then it's your signature. I do not see that form. It says plea and verdict.
We don't sign that. It's just the what he attests to. It's the defense and the judge, and then I signed the plea and verdict.
You did, that's what I was talking about. The plea and verdict was not included in the package.
Yeah, we
Do
only
y'all have,
have.
do y'all have 3 pieces of paper there?
Yeah,
Judge?
we have it. It's like-
Okay.
You have the form that says plea and verdict?
No, this is the same state.
And
This
the
is the
waiver.
same form
Is it the
twice.
same one?
No, it's the same page twice, right?
Okay.
What I thought.
So we're
Then
missing,
what's-
right, we're missing.
Hold on, Your Honor.
Hold on.
Here.
What's it? What is it?
This is the plea statement. We have 2 copies of the same page.
Mhm.
Okay, yeah, I got back from Deputy Norris. I sent him the one that the plea and verdict form. I'm not sure if he can send that over to you guys. I signed that one and I sent it over to Deputy Alton Norris.
He may have accidentally made 2 copies of one form and not one of each.
Tell them to stop saying the first name.
I'm sorry to interrupt. Can you just refer him by the last name? We don't go by first names inside the facility.
Okay, Deputy Norris.
Thank you.
I apologize.
Apologize.
He's resending it again.
Thank you.
He's going pro se, right?
Yes.
That's a risk. Is he the right thing?
Except the one we have the waiver on,
Oh, yeah.
number 4. Okay, let's see what we have.
Your Honor,
Yes, yes, sir.
on the plea and verdict, It has
Uh-huh.
a different, it has a different defendant's name on it, Philip Daniels.
Oops.
Yeah,
Go ahead and send it to us. We'll fix the caption
okay.
since it's late in the day. We'll fix the caption on this side before we send it back.
If you don't mind, I can go ahead and do that real quickly for you guys.
Okay, can you? Okay.
Okay, good.
Thank you, Deputy. We were just trying to
Okay, thank you.
white out, cut, paste or something. Don't tell anyone. I tell you, we're trying to get it all done here.
It's on YouTube though, Yana.
I know, right? To say everybody's here. Thank you for correcting the paperwork so that we get that correct. That is very important. When you're virtual, it's hard to fix things as fast as you would like, but I appreciate you, ASG Tortorello, for helping us with that.
Oh. Y'all just want to go over the calendar now while y'all waiting on that correction, or you finish sentencing him or not?
We can do, what are we doing for position 4? Is it Alex Bross? Bross?
Your Honor, initially, Ms. Gant asked for a breakout on that one.
You still need a breakout on that, Ms. Gant?
Your Honor, if we could stop the recording and then have the hearing.
Okay. Right, because we're the only ones left, so we could do that and then I'll start it back.
I just sent it. I hope it's okay. I sent it to Deputy
Okay.
Morris.
So what case we on now?
I think position 4, Ross.
We're going to 4.
You want the history?
You want the history on the record?
I'm unopposed to having history on the record.
All right, I will call this case 22 CR 001556H, Alex Bross. And I have a waiver of defendant's presence in court presented and signed by PD Gant. He is charged with 1 count of criminal trespass with the offense date of 3/17/2022. We'll go in breakout, so hold on a second. Am I off the recording, Ms. Lewis?
No, not yet. I was trying to wait till y'all finish. Are y'all finished with the plea? Are y'all totally finished with the plea?
No.
No, hold on a minute. You're correct. Making sure we have this, the last piece of it.
Is it just me or is somebody else having issues with email?
It's been kind
Yeah,
of spotty.
I got a little caution thing on mine. I don't know what's going on.
Yeah, let me
And remember when I was trying to sign on, mine was, I didn't have any recent emails for some reason, so I think
I think the emails went down again.
they went down again. I was gonna say we're blaming it on the weather today.
Oh, I sent it. It went through. Okay,
Okay,
good. Now it went through. It was in my outbox.
okay. Yeah, it's doing some interesting things.
That is probably why you didn't get the Senate sheet the first go around, Ms. Holly.
Mm-hmm. And his last name does not have an S, is that correct? Just William with no S?
My understanding, Your Honor.
Okay. While we're checking everything, just to make sure.
That's how it's on the calendar too, Your Honor.
Mm-hmm.
Your Honor, I just sent the old one. I guess
Okay.
you could just do your little botch job and take out the old name, put in the new name.
That's not a good word.
It's late. It's late. so-
It's late, I know.
Yeah, my mind is going in other directions right now.
Exactly, late
And
on a
mine is
Friday.
following it.
Everybody.
Did you receive it, Ms. Tortorello?
I thought I already sent the old one to Miss, I'll just resend it again, no
Just
problem.
resend it again. Uh-huh.
Mhm.
Hopefully it'll come through.
Right.
I was afraid we were gonna have technical
Right, with the
difficulties. Yeah.
terrible weather today. At least pre-trial, yours held up a little bit. Yours has been freezing though, right? When it wasn't raining?
For me,
No, pre-trial.
he doesn't look like a happy camper.
I know, he's gonna get me for it.
I sent it over.
Okay. Okay, I think he's got it now.
I think so.
Okay.
Your Honor, and it has the correct case number, it's just the name.
The name, okay, right.
I apologize to the court.
That's okay, I understand. We're trying to work with what we have. There we go. Thank you, everyone, for your patience and understanding.
And we've already gotten the waiver.
Mm-hmm.
Okay, I think we're cooking with gas. Yes.
Okay, great. Okay. And the, see where the defendant is? And correct that.
Yes. And what is
Mhm.
this fellow's name?
William, I'm sorry, Tyrone William
Okay.
Jr. with no S on
Okay.
William. Right. Is that correct, Mr. William? You have it's William with no S on your last name? Yes? Okay.
My name is Tyrone Williams with a S. That's my real
With a
my
S.
name.
Your name does have an S.
Yes, yes, ma'am.
Tyrone Williams Jr.
That's where I guess they booked it in like that, but my name is Tyrone Williams.
You're not a junior?
Yes, ma'am, I am a junior.
Okay.
But the S should be there.
Yes, Your Honor. However,
Yeah.
he was booked in without the S.
Okay, no problem.
Okay. It's a rainy Friday. Rainy night in Georgia? Okay. All right. So we've got everything for the plea now. And Madam Court Reporter, I think that would conclude our matter on the plea. Is there anything else that we have forgotten to take up that you need to remind me of?
Not that I know of, Judge. May I be
I'm
excused?
gonna put the pressure on you. No.
I'll take it.
We'll take it. Thank you so much. Pre-trial is not. I'm getting the difficult eyes from pre-trial.
Are we done with the plea, Judge?
Yes, we are done. I have both sheets now.
So you're complete with the sentencing on him?
And yes, I've already signed the sentencing sheet. So I have 3 pages, correct, Ms. Lewis?
Yes.
Okay, yes.
I just want to know.
Now, the only thing we need to make sure of is that we make sure the S should be there, or do we do also AKA with an S? Do we keep him the same way he was booked in?
Your Honor, from what I'm aware of and through practice, it's just at least what I know is like we keep them the way they're booked in. I don't know if
we don't want them to have issues at the jail and they're trying to get
Correct.
out.
They will start having issues at the jail. Just leave it the same way it's booked in so that it shows everything the same.
Okay, so leave it with no S. Okay, right, no S.
Okay.
And we apologize, Mr. Williams, you've got to keep that consistent
Yes, ma'am.
or else you'll be there
Again, I
waiting
understand.
for them to figure that out. So no, we'll leave it the way you were booked in.
Yes, ma'am.
All minds and hearts clear from Mr. Williams?
Indeed, indeed.
Indeed, indeed. Thank you for your time, Mr. Williams, and good luck to you.
Thank you for everything, ma'am.
All right, you're welcome.
All right, we're completed here in courtroom 2.
All right, yes. Thank you, Ms. Lopez.
Thank you, Your Honor. Have a wonderful
All right.
weekend. Thank you.
You too.
So are we going back to position number 4 now?
Yes, ma'am. We're going back to 4. And now can I stop the recording, Ms. Lewis, or you have to do it?
I'll have to stop the recording live.
Okay. All right. Okay.